Word. We are, if you want to loosely follow along in your book, we're on page 329, which, by the way, if you don't have a real estate manual yet, remember the Real Estate Commission does require it. So you can either get the hard book from Lane, or you can go to the Real Estate Commission's website and order the digital copy. But we're in chapter 11, if you're on the digital copy, on page 329. And we're going through the different provisions of the offer to purchase and contract. So a lot of this discussion, I just like to point out 329. A lot of this discussion is coming from that section of chapter 11. Another big part of this discussion, most of our forms have guidelines for completing. So for example, we have the guidelines for completing our standard offer to purchase and contract. And this is kind of a commonly asked questions. So if you're trying to ever fill out an offer, or you're not, you have a question and your BIC isn't around, this is a good resource for you. Your book, chapter 11, is a good resource for you. You guys got the resources out there. So I know one thing we said last week, when in doubt, find out. I didn't know isn't going to get you out of trouble, because the resources are out there. So guidelines for completing in your book. And where we are today is on let's make big where we can all see it, the offer to purchase and contract. We're spending most of our time on standard form 2T. We mentioned last week there's one for new construction. There's one for vacant lot and land. But our energy, most of our focus today is going to be on 2T. We'll look at vacant lot and land and new construction briefly. And with 2T, it's not uncommon to have addenda. So we're going to look at some of the more commonly used addenda today or tomorrow, just depending on what our afternoon looks like as well. Offer to purchase and contract. Off the bat, I want you guys to notice this form serves two purposes. It's an offer to purchase, and upon acceptance becomes a contract. So thank you, forms committees, for having dual purposes for this one form. We don't have to present an offer on one form and then write it up on a contract on a different form. So it's dual purpose. You're reminded of the guidelines. I do like that. When the forms have guidelines available, it'll say consult guidelines, in this case, form 2G. Our contract is for valuable consideration, the receipt and legal sufficiency of which are hereby acknowledged. Buyer offers to purchase, and seller, upon acceptance, agrees to sell and convey the property on the terms of this offer to purchase and contract, and any addenda or modification made in accordance with it. The first 2.5 pages of our offer to purchase and contract, the very first provision are terms and definitions. So we're spending the first 2.5 pages just defining things. We're describing what things are. We're defining what various terms and phases of the contract are. I think when you guys are working with buyers and sellers, this first 2.5 pages of discussion is the most important discussion we can have with our buyers and sellers. Make sure they understand the contract to closing process. It defines due diligence, earnest money. We'll see that in just a second. I don't think you can hand this to your buyers and sellers and say, read the first provision, because I don't think they're going to. I think they trust that you know what you're doing. I don't think you should sit down and read it to them. As adults, we typically don't like to be read to. If you want me to go to sleep, just give me a blanket and start reading, because that's like nap weather right there, right? So another thing for us being so familiar with these forms is we can have conversations with our buyers and sellers about the due diligence and the earnest money, explain to them the terms in the first provision, and help them understand. I'm a big fan of letting the forms put the words in your mouth. Why recreate the wheel? You don't have to come up with your own definition of due diligence. The form has defined it for you. You don't have to come up with your own definition of what earnest money, whatever. The form takes care of that for you. So the more familiar with the form you guys are, it's going to be easier to help put words in your mouth. I also want you guys to notice the first thing that we do is define the seller and the buyer. We'll talk more about that in just a second, but you're going to notice going throughout the contract that there's words that are capitalized that are not capitalized in their normal meaning, right? Buyer is typically not a proper noun. So if you're just discussing buyer, if you're just discussing seller, in typical grammar, they're not capitalized. The reason these words are capitalized in our offer to purchase and contract is because it's directing us to the fact that we define those words. So when we talk about buyer, we're not talking about any buyer. We're talking about this very specific buyer. Same thing with seller, same thing with property. So the first thing we do is define the seller and the buyer. I need full legal names of everybody. All the sellers that have to sign to convey the deed, and all of their spouses. If you have an estate situation where you have 20 heirs and all 20 heirs are married, it means you need 40 people to convey, to sign this deed. You need 40 people on the listing agreement, 40 people on the contract, 40 people on the deed. Same thing with buyers. Everybody that's going to purchase this property. Don't put Mr. and Mrs. My name is not Mrs. Ryan L. Campbell. I don't like to be called that. Everybody has their own name. So, you know, Ryan L. Campbell and Julie A. Campbell. You can identify our relationship. If you want to say Ryan L. Campbell and Julie A. Campbell, husband and wife, you're welcome to do that. You don't have to. I would suggest, for example, I had a mother-daughter buying a home. And just for clarification, I defined that relationship when I filled that in. So feel free if that may help the attorney. So we spell out who our buyer and sellers are, all of them, full legal names. The property, this property shall include all the real estate described below, together with all pertinences thereto, including the improvements located thereon and the fixtures and personal property that we'll get to in paragraphs 2 and 3 below. We'll talk a little bit about 2 and 3 below. Well, there's a blast from the past. Who remembers this big fancy word from pre-licensing? What does appurtenant mean? If something's appurtenant, what does it mean? Yeah.
Goes with.
That's right. It goes with, it runs with the land. So when you convey this property, all pertinences are going to run with it, including all the improvements located. So we're not just talking about the structure now. We could be talking about the shed and the fence and all the improvements located. Probably about, I don't know, time gets away from me, 7 years ago, 8 years ago, something like that. The forms committee added, we have blue notes in our forms now, and in just a minute, we're going to see a red warning. So the blue notes and the red warnings are, they're help to draw our eye to them. Their point is to help grab our attention so we see them. So our first blue note says, if the property will include a manufactured mobile home, buyer seller should consider including the mobile home provision and the additional provisions addendum standard form 2A11T with this offer. The additional provisions addendum, this is one we looked at last week. If you have a mobile home, if you wanted an expiration of offer, if you need a septic inspection, various additional provisions. One thing I like a whole lot about our contract, when there's a need to use an addendum, our contract will tell us, use this addendum. So again, if we're familiar with the forms, you don't have to wonder, which addendum do I need? Which one should I use? Let the forms help you. Let the forms direct you. So our additional provisions addendum, we're told in our first note. Then we have a place for street address, city, zip, county, and North Carolina. These are North Carolina forms. Our license is a North Carolina real estate license. So our license says that we can engage in the transfer of property, real property, for any property located in the state of North Carolina. If you go across the street and it's Virginia, you cannot assist in that property. Your North Carolina license is only good for North Carolina. Our next blue note tells us government authority over taxes, zoning, school district, utilities, and mail delivery may differ from the address shown. You may have some rural places in the world where the street address and the mailing address are different. So make sure you get the street address and not the mailing address, for example. And then here's the place for our legal description. And we are instructed to complete all applicable fields. We need as much information in this legal description as what we can. So everybody, not just the agents, but the lender, the attorney, the surveyor, the appraiser, everybody knows what property we're talking about. Everybody's very clear on the parcel of land that's being conveyed. If it's not applicable, put NA. Remember we said last weekend, we're never going to leave a blank blank. So as much information as you can to make sure we're all on the same page. And then we get to the purchase price. The purchase price is paid in US dollars upon the following terms. So this blank, this first line right here is the amount that the buyer is offering to pay the seller. What is the buyer willing to pay for the property? We're going to deduct from that line. So the first thing we're going to deduct from that line, and I can do this a little bit, but I'm going to run out of room in just a second. So let's say our purchase price is $100,000. Can you guys still see that okay? It's not too small. Okay. So let's say, and I'm trying to get it just right. It's about as good as I can get it. Let's say our purchase price is $100,000. That's what the buyer's offering to pay the seller. And from that line, we're going to deduct other things. One thing that is very common in a real estate transaction is the due diligence fee. Now we're going to define due diligence fee, due diligence period on the next page. So we'll talk more about that. But we're told that the due diligence fee is made payable and delivered to the seller by the effective date. Again, we'll define the effective date on the next page as well. So when is the due diligence due? Is it due 3 days after we go under contract? Is it due a week from now? It's due when? By the effective date. That's the day that we go under contract. The buyer has a duty to deliver a check to the seller. The agents can assist, but the buyer has a duty to deliver due diligence to the seller by the effective date. What if they don't? We got that covered in the contract. We'll see that in just a second. So they're delivering the seller by the effective date, and then we're going to check in what manner. Is it going to be cash, personal check, bank check, wire transfer, electronic transfer? The only caution I give you guys about doing wire transfer or Cash App, I'm hearing that question a lot. Can buyers not pay sellers on Cash App? Get the lender's approval first. All lenders are different. Not all lenders are created equally. So before you start doing wire transfers and Cash App, make sure the lender is down with that. Because if the lender doesn't approve it, then the buyer won't get this due diligence credited back to them at settlement. So buyer's agents, do that service to your buyer. Pick up the phone, call the lender and say, hey, can we do that via Cash App? Everybody good with that? Every lender is different. So let's say we negotiate back and forth. Certainly not true to this market, but let's just pretend that the due diligence is $500. So if $100,000 sales price, $500 due diligence. And then we're going to talk about earnest money. Initial earnest money. Spotlight back. Initial earnest money made payable and delivered to the escrow agent that we're going to define on the next page. It's going to be cash, personal check, official bank check, wire transfer, electronic transfer. And the initial earnest money is due either check one by the effective date or within 5 days of the effective date of this contract. So due diligence is the effective date, earnest money is the effective date, or within 5 days, whatever you select. There may certainly a point for negotiations. We may also have additional earnest money. I will talk some scenarios about that in just a second. Additional earnest money made payable and delivered to the escrow agent named in paragraph 1 no later than 5 p.m. on this date. Time being of the essence. Who remembers what time being of the essence means? That's right. I think John just dropped the mic. That's a drop dead date and time, and it's over. A time, 5 p.m. time being of the essence. That's a drop dead date and time. So if we're negotiating additional earnest money, and again, we'll talk about some scenarios in just a second. If we're doing additional earnest money, we need to fill in a date and understand that that additional earnest money is due no later than 5 p.m. The other thing you'll note with additional earnest money, personal check is not an option. It's cash, official bank check, wire transfer, electronic transfer, again, with the lender's approval for Cash App or Venmo. The thinking being is that with additional earnest money, we may be close to settlement. And if we're close to settlement, nobody wants to delay settlement waiting on a personal check to clear the bank. So because additional earnest money happens typically later in the transaction, personal check is not an option for additional earnest money. Please understand, whether it's initial or additional, whether it's initial earnest money or additional earnest money, it's still earnest money. It's all earnest money. We're going to define earnest money and talk more about that in just a second. There's no wrong way to approach this. I've seen some agents maybe offer $0 in initial, and then they may do additional, might be due whenever our due diligence date is over. 6 to 1, half dozen the other, isn't it? Think about it. Buyer puts down earnest money, they terminate within their due diligence, they get their earnest money back anyway, right? That's their right, and we'll define that in a second. If you do additional earnest money, no initial, and you have it due on due diligence, the buyer can still terminate with due diligence. They just don't have to pay any money because we've never made it through due diligence. I've seen some, again, there's no wrong way to do this. It's completely negotiable between the parties. I've seen some cases where maybe the buyer offers $500 and the seller says, you know what, I really want $1,000 earnest money. And the buyer says, okay, I'll tell you what, I got $500 to give you now. I can give you $500 additional next week or 2 weeks from now when I get paid. So initial and additional, it's all negotiation point. Okay, it's whatever the parties agree. And again, we'll define earnest money in just a second. But I don't want you guys getting tripped on thinking additional is something different than initial. It's all negotiable and it's all still earnest money. The rest of these lines, we're just going to mention kind of briefly. A loan assumption, by assumption of the unpaid principal balance and all obligations of the seller on the existing loan secured by a deed of trust on the property in accordance with the attached loan assumption addendum. It tells us what standard form that is. So if the buyer is assuming the seller's loan, then we would have a down payment or a deposit to put on that line. And once again, if the buyer's assuming the seller's loan, then we're instructed to use the loan assumption addendum with this offer. Seller financing, if the seller is going to act as the lending institution, pretty much, there might be a down payment. We would have that there as well. In accordance, again, we're instructed to see the attached seller financing addendum. And you could have new construction. There might be a building deposit. So if you have a building deposit, you would put that amount here. And again, we're instructed to see the attached new construction addendum. The new construction addendum, we will look at later today with the rest of our addenda. So we will see that. I've never, ever in my entire life heard of a situation where every single one of these lines is used. I couldn't even imagine that kind of nightmare, right? So it's going to be, call me if this ever happens to you and your attorney. But I think what we see most of the time, especially, and let's just keep this simple, typically what we're going to see in a normal transaction, whatever that means, you're going to have the balance, you're going to have due diligence fee, you're going to have some form of earnest money. And the way this form is designed, if you take this top line minus everything in between, then this bottom line is reserved for, and I cannot do math in my head at 9:30 on a Saturday morning. So if you take 100,000 minus 1,500, then you're going to have 98,500. And that's the balance of the purchase price in cash at settlement, some or all. And that's cut off a little bit, so we see that, but some or all may be secured by a loan, by financing is what that says. So what I want you guys to see here, the top line minus all the lines in between equals the balance. You guys make sure that bottom line is correct, especially if you start negotiating. It's easy the first time you do it, right? But then the seller counters with the purchase price and they counter with a higher due diligence. So as these numbers, the purchase price, the due diligence, and the earnest money change, make sure that balance line, that bottom line is correct. Make sure your math is right. Questions or comments on that piece of it, defining our purchase price? Yeah, Robert.
Hey, Julie, I think it's worth noting for, I guess, what you call real world. Once that initial offer has been presented, sometimes a lot of that negotiation happens in a text or an email. It doesn't actually show up on a form. So
that's correct.
And I went through that last week and realized that the agent, when she went back to finalize what we agreed on a price, she didn't change any of the numbers below the purchase price. And we had to go back and almost start over. It was crazy.
So thank you, Robert. And that's very, very real in practice in the real world. So, you know, buyer's agents, make sure you're presenting it. Listing agents, check it to make sure it's right. Again, we have that duty, our buyer and seller. But to Robert's point, typically we're not, you know, the old school way to do it is to have this form in our hands, cross out initial date, put in the new amount. Well, guess what? It's 2022. We have programs like dotloop out there now that we don't have to do that. So in practice, what we're seeing is, you know, listing agent and buyer's agent are negotiating on behalf of their clients via text or email. So first off, remember, what do you document? Everything. So as you're negotiating with that other agent, make sure you hang on to that communication. If it's happening over the phone, if it's happening in person and over the phone, I would follow it up with an email or a text so you have it in documentation. You know, the other agent calls you and says, my guy's counter with this, this, and this. Per your call, we're discussing your counter of this, this, and this. I would absolutely follow that up with documentation. Did I tell you guys about my app last week? My app on my phone. I have a text to email, and I can convert text messages to a PDF, and that PDF can go into my transaction file. So I saw one agent sitting there one time, she was taking screenshots of all her text messages at the end of the transaction. I was like, oh, let me tell you about something. So I became her hero that day. So text to email, just go to your Google store, your iPhone store. There's several different programs out there. So you can just, you know, kind of pick one and play around with it. Thank you, Robert, for bringing that up. We got to make sure, again, listing agents, no, you're not the one writing the offer. But you owe it to the seller to make sure that this bottom number, to make sure this top number minus all these numbers is accurate, is correct. I understand things are crazy busy right now, but that doesn't give us an excuse not to properly. That shouldn't give us an excuse to properly do our job. Sometimes slow down, take a big deep breath, So balance, let me just make sure we see this. Balance of the purchase price in cash at settlement, some or all which may be paid with the proceeds of a new loan. Other questions or comments about this section? We're defining the purchase price and how that purchase price is going to be paid. Okay. If the parties agree that buyer will pay any fee or deposit described above by electronic transfer, seller agrees to cooperate in effecting such transfer, including the establishment of any necessary account and providing any necessary information to the buyer, provided, however, buyer shall be responsible for additional costs, if any, associated with the transfer. Again, if your buyers want to pay due diligence by wire transfer, Cash App or Venmo or PayPal, just run it by the lender. Just make sure the lender's on board with that. The bottom of our first page, we got all sorts of things going on down here. So let's see what we got. Once you join, if you're not already, once you join the National Association of Realtors, you get to rock the capital R. You get to rock the Realtor R. So by being a member of the National Association of Realtors, that gets you into the state level, the North Carolina Association of Realtors. If you're not a realtor, you cannot use these forms with the capital R on them. If you're not a realtor, you're not a member. If you're not a member, you'll have to have an attorney draft stuff up. I think, y'all don't hold me to this, but I think NCAR has some non-member forms available, but not many. So obviously there's two big advantages, in my opinion, of joining the National Association of Realtors. One, the forms that we can use. You don't have to have an attorney. But two, the public, I think, recognizes that capital R. They may not know what it means and they may not know what it entails, but they recognize it. It's like brand awareness, right? So it's another way to help us brand ourselves. We're told that this form is jointly approved by the North Carolina Bar Association and the North Carolina Association of Realtors. Please note, the Real Estate Commission does not write the forms for us to use. The Real Estate Commission does not provide us with these pre-printed forms. It's NCAR and it's the NC Bar Association. The only thing the Real Estate Commission provides us is working with real estate agent disclosure, the RPOs and the MOG. Everything else is an NCAR form. We have our equal housing opportunity logo. And then we're told this is standard form 2T. Again, you don't need to know the 2T, but sometimes when you're looking through hundreds of templates trying to find this offer to purchase and contract, if you can just stick that in the back of your head somewhere that it's 2T, it'd be easier to find. And then we have when the form was last revised. I hope this goes without saying, but make sure you're always using the current forms. This isn't as much of a problem as what it was back in the day when we had paper. Back in the day when we had paper, agents would print out like 10 of these at a time and put them in the trunk of their car. So they'd always have a contract ready to go. And then the forms would update and they wouldn't update the forms in their trunk. So now they're literally driving around with outdated forms. Today, we have programs like dotloop, ZipForms, DocuSign that update the forms for us. So that's one big advantage. Whatever contract your firm has with dotloop, when NCAR sends dotloop a new form, they'll automatically fill it in for us. So today it's not as, it's a lot easier, you know, but still, if I still have copies of a contract in my trunk. What if the internet goes down and the buyer says, I want to write an offer up right now? I'm plan B, you know, I'm old school, I know. But just make sure if you have any paper copies floating around, make sure that when the forms update, you're using the current. Always make sure you're using the current. And if you're not sure, you can always go to NCAR's website. If you don't have an account yet, you got to be a member. You got to be affiliated with a firm and be a member. But if you don't have an account yet with NCAR, you can create one. And then they'll always tell you what the most current form is. There's a whole section called forms. And they have every single thing that they've produced.
Hey, Julie, can I ask you a question?
Of course.
Good morning to you.
Good
So
morning.
let's say, for example, I'm representing myself and I'm not incorporated. Well, I'm not part of any firm. And so I can't use the R forms, and I'll come up with my own form. And then I go to Julie, the seller's agent. And what would Julie do with my form? Because it obviously takes two to have a
Correct.
contract.
Correct. So you, because in this case, because you're buying the property, you would be a party to the contract. So technically you could draft your own form. Parties to the contract can draft. I'd still advise you to talk to an attorney, you know, but,
Right, I assume I've done that. Assuming
okay,
I've done
so
that.
you talked to an attorney, so you brought me another, so
But
there's a
I'm forcing you
rule.
to, so to speak, with a form that you don't necessarily have a
Sure.
preference to deal with.
So there's a rule, it's rule 112, I think. We'll look that up in just a second for you, Ariane. But there's a rule, a commission rule that defines that. The commission rule says, guys, these standard forms that NCAR provides are not the only forms I'm allowed to use. I'm allowed to use any form, any pre-printed form, as long as it follows commission rule A.0112. So when you present me, builders a lot of times have their own forms as well.
Mhm.
So when you present me with an offer that doesn't look like this,
Mhm.
what I should be
Mhm.
doing is verifying that this is a form that I can, I'd probably call you and say, hey, where did an attorney draft this? Did you, I probably have a couple questions for you, but I certainly wouldn't advise my sellers not to ignore it because it doesn't look like this.
Mhm.
And that's one thing I think is might be a common misconception, is that standard forms are it. If it's not a standard form provided by NCAR, then we can't use it. And that's just not true. That is just not true. As long as it follows, and I'll look that up on break, make sure I get the right rule number for you. Because right now I'm just thinking off the top of my head.
Thank you very
But I'll
much.
make sure I get that right for you so that you, if you're in that situation, Ariane, you can say, oh, wait a minute, let me make sure it follows this.
Thank
And
you.
then advise your sellers accordingly, of course. Donna, you work with builders. Do you guys have your own contracts?
Yes, we do.
So,
Yeah.
and so when the
It's
buyer
so-
comes in, you
so
provide them,
detailed.
right? Do what?
It's so detailed too, because they've been sued so many times that they have
Oh.
all these additional addendums and all. So,
That's why
yeah.
our offer to contract, purchase contract is 15 pages. A lot of
Yeah.
what we're seeing here is the result of a court case somewhere. Somebody sued somebody.
Yeah.
So yeah, I mean, it's, most builders, like I said, we work with 2 builders and they each have their own contract. So, yeah, if you get one that doesn't have NCAR on it, it's okay. It's all right. Just make sure that it's still in compliance, still follows commission rule. Other questions so far on page 1? Should buyer fail to deliver either the due diligence fee or the initial earnest money deposit by their due dates, or should any check or funds paid by buyer be dishonored for any reason by the institution upon which the payment is drawn, buyers shall have 1 banking day after written notice to deliver readily available funds to the payee, known as the seller. So the question comes in, what if the buyer doesn't deliver the due diligence by the effective date? Or, oh, horrors, what if the buyer delivers the due diligence and the check bounces? That has happened. It happens sometimes. In the event that the due diligence or earnest money is late, or either of those checks bounce, the seller has to provide written notice to the buyer. That's what triggers all this. That's what starts all this. The seller has to provide written notice to the buyer. And upon receiving that written notice, the buyer now has 1 banking day to get them readily available funds. Don't you give me another personal check for due diligence. Your first one bounced. Now I want readily available funds. You will note again that personal check is not an option. Cash, official bank check, wire transfer, or electronic transfer. If the buyer doesn't deliver the required funds 1 banking day from written notice, seller shall have the right to terminate this contract upon written notice to the buyer, and seller shall be entitled to recover the due diligence fee together with all earnest money deposit paid or to be paid in the future. So seller gives written notice, buyer has 1 banking day to provide funds. If they don't do it, seller has a choice. Does that say the seller has to terminate? No, seller has a choice. They shall have the right to terminate. And if they do, they'll get the due diligence and the earnest money. And if the buyer's not willing to sit down and write out a check, the seller can sue the buyer. They have that right to collect. And if the buyer's not willing to do it voluntarily, the seller may. And as agents, as the listing agent, what are we gonna tell our seller to do? Call their attorney. What should I do? Should I sue them? Should I sue them? To me, that's offering legal advice. If you're asking me if you should sue somebody, discuss with your attorney, take your contract with you when you meet your attorney and let them advise you on what you should do. In addition, seller may be entitled to recover reasonable attorney fees and court costs. So if they do decide to sue the buyer gets to pay for that too. So, buyer's agents, make sure your buyers have the money in the bank and it's not going to bounce and this isn't going to be a thing. Paragraph 23 is new as of the form update July of 2021. Paragraph 23 is new. And paragraph 23 addresses what happens in the event of either party's breach. So we'll get to that. They just kind of tacked it at the very end of our contract. So we'll see paragraph 23, and it spells out what happens in the event of buyer's breach, what happens in the event of seller's breach. This written notice that the seller has to provide, there is a form that we have available to us. We'll actually look at that when we come back from break. It could just be as informal as an email. It's kind of my thinking, when they provide us a form, why not use it? It looks more official, it looks more legit than me sending an email with typos and grammatical errors, right? So this way the form takes that, it takes that away. It allows us to, like I said, look more legit. So we'll look at that form in just a minute when we come back from break. Questions on that? What if it's late or what if it bounces? Y'all want to hear a crazy story? Back in my admin days, my administrative days, I maintained the trust account for the office. My BIC was ultimately responsible for it, of course, but he let me maintain it. And we had an agent that was working with a woman that was going to buy 3 houses, one for herself, one for her mom, and one for her sister. So they were going like new construction, like cute little townhomes, but she wanted everybody to be side by side, right together. They went under contract. They brought me 3 earnest money checks. All 3 of those suckers bounced. I called the buyer's agent. I said, what's up? They dug a little deeper. Y'all, this woman forged a proof of funds letter from the bank. She forged it from the bank saying she had the money because she truly believed in her heart of hearts that she was getting money from overseas. She truly believed somebody from overseas was sending her money. So since this is coming, let me go ahead and put a contract on 3 properties. I don't have it yet, but I'll just tell them I do. People are people, you guys, and people will do some crazy things. I got the mail that day and I was like, why do I have 3 letters from the bank? My gosh, what do they want? Earnest money bounce, earnest money bounce, earnest money. I was like, yeah, this is, I was out. That got above my pay grade fast. Some buyers are liars. That's the old saying in this industry. Buyers are liars and sellers are too. So, all right, let's define our earnest money. And this is really short right here. When we get done with this offer to purchase and contract, we're going to spend some more time talking about the earnest money and the various rules when it comes to the trust account and stuff that we need to be aware of. So this is just a very brief discussion of our earnest money discussion. We'll talk more about that later today. The contract defines the earnest money deposit It's the initial earnest money deposit and the additional earnest money deposit and any other earnest monies paid or required to be paid in connection with this transaction, collectively known as the earnest money deposit, shall be deposited promptly and held in an escrow account by the escrow agent that we're getting ready to define until closing that we're getting ready to define, at which time it will be credited to the buyer or until the contract is otherwise terminated. In the event this offer is not accepted or a condition of any resulting contract is not satisfied, then the earnest money deposit shall be refunded to the buyer. And again, we're instructed to see paragraph 23 below for remedies of breach. So we'll see that eventually. Earnest money, think of earnest money as the buyer's good faith. The buyer is showing the seller that they're a serious buyer. The buyer is showing the seller that they're not just out there kicking tires. I'm genuinely interested in your property. Sellers want to know that buyers have a little bit of money in the bank. Sellers want to know that they can, in addition to the loan, afford to purchase their home. The earnest money deposit's a negotiable amount. There is no formula, there is no set fee. The Real Estate Commission is incredibly helpful when it comes to the amount of the earnest money deposit. The Real Estate Commission says, whatever the buyer is willing to offer and the seller is willing to accept. Gee, thanks. That's a big help. It's a completely negotiable amount. And earnest money does not create a valid contract. So if the buyer offers 0 and the seller accepts 0, we have formed a contract with how much earnest money? None, 0. Completely negotiable amount. There is no formula, there is no equation, there is no, well, if this is the purchase price and the blah, 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 whatever the buyer is willing to offer and the seller is willing to accept. Last week, we talked about, I think we did, we talked about if your buyer ever wants you, you're negotiating the offer and the buyer says, here's my earnest money check. Will you hang on to this for me? You're not under contract yet, but they ask you to hang on to the earnest money. We can, as provisional brokers, you can't, right? As PBs, you need to get that to your BIC because you can't walk around with somebody else's money. This provision is addressing what happens if that offer never becomes a contract. If the offer never, they give you the earnest money, they say, hang on to this, and then we can't work it out. It never becomes a contract. The buyer doesn't owe earnest money until we're under contract. So if the offer never becomes a contract, then we need to get it back to the buyer. Don't deposit it. We need to get it back to the buyer or destroy it in accordance to their instructions. Do you want me to shred it? Do you want me to write void on it? Do you want me to write void on it and shred it, right? Or do you want me to get it back to you? But if the offer never becomes a contract, then the buyer doesn't owe money. And this second thing is addressing a condition of any resulting contract is not satisfied. It's pretty much referring to the due diligence period. We'll define that later in this contract as well. So is everybody good with that piece of it? If the buyer terminates within due diligence for any reason or no reason, they will get their earnest money back. Again, we're getting into define our due diligence in just a second. We need to define the escrow agent, insert the name. This needs to be the name of the firm. If it's the listing firm that has a trust account, put the listing firm's name in. Don't put the listing agent. If the attorney is going to act as the escrow agent, put the name of the firm in, not the individual attorney. Of course, unless the attorney is the firm, right? Always put the firm name in, not the individual. Buyer and seller consent and disclose by the escrow agent of any material facts pertaining to the earnest money deposit to the parties of the transaction, the real estate agent and buyer's lender. So anything that's about the earnest money deposit, parties are agreeing that we need to share that with the escrow agent. we have a note that discusses disputes. In the event of a dispute between buyer and seller of the disposition of the earnest money, a licensed broker is required by state law, an escrow agent, if not a broker, to retain the earnest money deposit in the escrow account until the escrow agent has obtained a written release from the parties consenting to the disposition, or until disposition is ordered by a court of competent jurisdiction. If a broker or an attorney licensed to practice North Carolina is holding the earnest money, the broker or attorney may deposit the disputed monies with the appropriate clerk of courts in accordance with this North Carolina general statute. When we get to paragraph 23, which is our remedy, it's pretty clear. Our contract is pretty clear about what happens to earnest money and due diligence if the buyer's in breach, if the seller's in breach. And we'll spell it all out some places a couple times. However, despite how clear the contract is, if we terminate, the parties have to agree to release the earnest money. It doesn't happen automatically. So you terminate, I'm so sorry, bad day. You terminate, the money just doesn't automatically go to whichever party. The parties have to agree to release it. And if either party is not willing to sign that agreement to release, then the earnest money is considered in dispute. And what this paragraph is saying is that the escrow agent, regardless of who they are, if they're the real estate firm or the closing attorney, the escrow agent can't make a decision about what to do with that earnest money. The escrow agent can't say, well, the contract says it should go to the buyer. That's not up. It's not the escrow agent's money. They're safeguarding it. They're holding it for the buyer and the seller. So if they're in dispute and they don't agree to release it, the escrow agent waits X amount of time. And I don't remember what that X amount of time is. But after X amount of time, if they don't have the written release, the escrow agent has the right to turn it over to the clerk of court's office and let the two go hash it out in front of a judge in small claims courts. And the judge is going to look at the contract and says, well, it's pretty clear right here what happens to the earnest money. You terminated, so what's up? Why are you wasting my time? And I hope he makes them feel like that too, because the contract is very clear about what happens to the earnest money if we terminate. What we need to understand is that the escrow agent cannot release it unless the parties agree, even if the escrow agent is an attorney that is perfectly capable of translating the contract. Comments on that? Parties agree that a real estate brokerage firm acting as the escrow agent may place the earnest money deposit in an interest-bearing trust account, and that any interest earned shall be dispersed in the escrow agent monthly in consideration of the expenses incurred by maintaining such account and records associated therewith. So can we have an interest-bearing account? Sure can. Parties sign this, they agree to it. If the firm is the escrow agent, they're collecting interest. Each month they collect interest, they need to transfer that from their trust account to their operating account. Because remember the basic definition of a trust account, that's an account that has somebody else's money. So as you earn interest, you got to get your money out of the trust account, put it in your operating account. Then we define the effective date. We're still defining stuff. We define the effective date. The date, here's our magic moment in time. The date that the last one of buyer or seller has signed or initialed this offer or final counter offer, and two, such signing or initialing is communicated to the party making the offer as the case may be. So you have to have the last party sign, the last offeree sign, and then communication of acceptance has to cross the line and go back to the party making the offer. That's our effective date. These two things make up this magic moment in time when it goes from being an offer to a contract. You have acceptance, and then communication of acceptance crosses the line. let's pretend you're up late at night one night in the throes of negotiations, and your parties sign at 11:30 p.m. and you communicate acceptance at 12:05 a.m. the next day. When's your effective date? The next day, because I got to have both pieces. So even though you signed today, communication wasn't delivered until technically tomorrow. Parties agree and acknowledge that the initials on the lines at the bottom of the page are merely evidence of having them reviewed, and that the complete execution of such initial lines shall not be conditioned of the effectiveness of this agreement. So I'm going to go back up for 1 second. The bottom of every page has a place for buyers and sellers to initial. Every page, 1 through 15. What that last sentence is saying, if your buyers forget to initial this page, it doesn't affect the validity of the contract. What makes this a valid contract is because they signed it, not because they initialed each page. When they're initialing each page, they're supposed to be saying, yeah, I read page 1, I'm good with that. I read page 2, I'm good with that. Again, I don't think we're having these problems now that we're in the dot loop world, because you and I can put initial boxes on all these lines and they can't finish it until they're done. So it's different than back in the day when we were doing it, you know, on paper and pencil. So as agents, when you're setting these up, just make sure, make it a point to all the initial lines. If somebody needs to initial it, that they have that there. How are we doing so far? Any questions? Anything about anything we talked about so far? Doing good so far?
Just very important to mention, Julie, is that that effective date and being communicated. A signed contract, like I say, just to put it out there again, a signed contract is not valid unless it's communicated.
That's right. It's a two-piece puzzle, isn't it? You don't have a completed puzzle until you have both pieces signed and communicated. The person making the offer has to know that their offer's been accepted.
And if I sound like I'm speaking from experience, let's just.
Do you have a
until it's
tough week, Robert?
communicated. It's not a valid contract until it's communicated. That's all I'm saying.
Say it again for the guy in the back, right?
Yes, exactly. Or lady in the back.
You're right. I apologize for the person in the back. There you go.
As the case may be.
That's right. That's right. That's right. So, okay, let's go ahead and take our first break. Let's take 10 and we come back. We're going to look at that form. What happens if that check bounces or is late? And then we're going to jump back into our contract. So it's 10 o'clock. So let's come back at 10:10 and we keep going. All right. So you guys get your re-up. Ooh, look at Alicia. She's got a big old thing of coffee. Hold that thing up again. There you go. That's what I'm talking about. That's how you do post licensing on a Saturday morning, right? All right, so let's see, we're back. And so let's take attendance. Just a couple of things, let's get off the contract for just 1 second. I want to point, Arian kind of alluded me to something. So let's go to the Real Estate Commission's website, ncrec.gov. Remember, this is a plethora of information. And probably one of the more important things, if you guys look under resources, under the resource tabs, and then you have license, law, and rules. Resources, license, law, and rules. So if you're ever looking for the current license, law, or commission rules, you can come here. License laws first and then rules. The one we were just talking about is a commission rule. So if you get, as a listing agent, if you get an offer, if it loads, if you get an offer on a form, not on our standard forms, and you want to know, does this comply? Does this follow the rule? It is rule A.0112. So you can come right here, A.0112, offers and sales contracts. And this tells you, this is the rule that says we can use any contract that's drafted by an attorney as long as it meets this rule. So Ariane, to answer your question further, as long as it has this information, as long as it provides this information, then we are allowed to use that form in the transaction. So that's that. You know, and I get it, you guys. Part of it is it a law? Is it a rule? You know, keeping up with what's a law and a rule, that's the challenging part. But remember, the commission has this speed bar up here. So if we did offers, I'd be willing to bet somewhere in here tells me rule A.112. Maybe I need to search a little bit better, but you know, you can always try to use the speed bar to help get you to that information, what you're looking for. And remember, you got your BIC as well. So if you need them as a resource, but yeah, resources, law and rule. Yes, you probably still have your pre-licensing book laying around, and that's fine, but your pre-licensing book is out of date already. I don't know when you got it, but I tell you, your pre-licensing book is already out of date. So it's so important that we're always looking at the current law and rule. So thank you, Ariane, for that question. It spawned me to share this with you guys.
No, thank you for the additional input.
Yep, sure, thank you. And the other thing I just want to show you guys, form 355T. This is notice to buyer to deliver cash, electronic, official bank check, wire transfer, electronic transfer. So if the earnest money or the due diligence is late, or either one bounce, like I said, yes, technically you can send an email and there's nothing wrong with that. But if you want to make it look official, we got a form for that. I'm kind of a believer of, if they provide us with a form to use, why try to type it out in an email? Why not just provide the form? So if you're a listing agent, those checks bounce, you're going to assist your seller in delivering written notice. And one way you can deliver written notice is using this form. And this form pretty much just takes that paragraph that we just read and spells it out. They just put it in nice, neat bullet form and everything. So pretty much everything we just said. Questions on that? Use the forms to your advantage. Okay. So let's get back into our contract. Let's see, we define the effective date. We're going to spend some time now talking about due diligence, due diligence fee, and due diligence period. Make sure we're all good here. First off, let's define due diligence. Due diligence is the buyer's opportunity to investigate the property and the transaction contemplated by this contract, including but not necessarily limited to the matters described in paragraph 4 below, which we'll get there, to decide whether in the buyer's sole discretion will proceed with or terminate the transaction. So what is the buyer's due diligence? What does just due diligence in general mean? Due diligence is the opportunity, in this case for the buyer, to learn as much about the property as they possibly can to decide, now knowing what I know, do I want to proceed with or terminate this transaction? Everybody remember, North Carolina is a caveat emptor state. What's caveat emptor mean?
Buyer beware.
Buyer beware. Sellers have no duties or obligations to disclose anything. A solution to North Carolina being the caveat emptor state is to give the buyer this due diligence period, to give the buyer the opportunity to learn about the property. Even if the seller says, yeah, that works, it's perfect, I've never had a problem with it. The buyer, remember, buyers are liars, sellers are too. So the buyer, I'm not saying that they shouldn't rely on what the seller says, but they really shouldn't rely on what the seller says. It's up to them to learn about the property. It's up to them to investigate, to inspect, to decide if they want to buy. And guys, once the buyer hires an agent, we take on that responsibility with them. Once the buyer hires us, we take on that responsibility to help them and invest and inspect and learn about the property as much as they can. So then we have the due diligence fee, a negotiated amount, if any, once again, completely negotiable, paid by the buyer to the seller with this contract for the buyer's right to terminate for any reason or no reason during the due diligence period. The due diligence, the buyer is paying the seller the due diligence for the right to terminate. So everybody see that. This is so important. There's a common misconception out there on the streets. And that common misconception is that the buyer's paying the seller for the seller to take their home off the market, not have any more showings and not accept any more offers. When we go into contract, can the seller still have showings? Absolutely. When we go into contract, can the seller accept a backup contract? Absolutely, if they want to. Our backup contract addenda is one of the forms that we'll look at. So don't fall into the common misconception. The buyer's not paying the seller to take their home off the market and make it unavailable to others. The buyer is paying the seller for the right to terminate. For what reason? For any reason or no reason at all. They could have a terrible home inspection report come back, 150-page home inspection report. Buyer goes, and turns around and runs away afraid. They're terminating for a reason. They could literally wake up the next day and say, nah, I don't want to buy this house. It's their right to terminate for any reason or no reason during the due diligence period. What questions do I have on that? Again, completely negotiable amount, whatever the buyer's willing to offer and the seller's willing to accept. It shall be the property of the seller upon the effective date, there it is again, and shall be a credit to the buyer at closing. Remember when we did our closing disclosures? We told our buyer, when you pay due diligence, it'll be credited back to you at closing. So it's spelled out in our contract. Due diligence fee shall be non-refundable except in the event of material breach of this contract by the seller, or if this contract is terminated under paragraph 8N, which we'll get to, or is otherwise provided. If the buyer exercises their right to terminate, the seller will keep the due diligence fee. Just because the buyer chooses to terminate doesn't mean the buyer is going to get their due diligence back. That's what they paid the seller for, is the right to terminate. The seller cannot sue the buyer because the buyer paid for that right. So if the buyer terminates, yes, the seller is going to keep it. That's what the buyer paid for. The only time that the seller would have to give the due diligence back is if the seller's in breach And we'll see the seller's remedy for breach in that new paragraph 23. Paragraph 8N is addressing what happens if the house burns down. And actually, it doesn't apply to due diligence anymore. So I might have just found an error in the contract. But for our purposes, if the seller is in breach, that's the only time the seller will have to give back the due diligence. Buyer and seller each expressly waive any right that they may have to deny the right to conduct due diligence or to assert any defenses to the enforceability of this contract based on the absence or alleged insufficiency of any due diligence. It being the intent of the parties to create a legally binding contract for the purchase of the sale without regard to or the existence of the amount. Oops, that was a bad line. So again, buyer offers 0 in due diligence, seller accepts 0. The two have contractually agreed to no due diligence fee. In this market, the buyer offers $100,000 in due diligence. They find something wrong with the electrical and terminate. They've lost that $100,000. That's what they paid for. Every single one of your buyers has a different risk tolerance. Not all buyers are willing to risk $100,000. That's not up for me to decide what your risk tolerance is. My job as the buyer's agent is to make sure you understand the risk that you're taking. Make sure that you understand if you put up $100,000 and you terminate for any reason whatsoever, you will lose that $100,000 due diligence. That's my job. Don't look at your buyer and say, don't do that. You look at your buyer and say, this is what happens. And then we have the due diligence period beginning on the effective date and extended through 5 p.m. on. And our due diligence period is another drop dead date time. If our due diligence is up to date at 5 p.m., that means at 5:01, it's too late. 5 p.m. is a drop dead date and time. Questions on due diligence period, due diligence fee? Okay, still defining things. We're going to define settlement. Settlement is the proper execution and delivery to the closing attorney of all documents necessary to complete the transaction contemplated by this contract, including the deed, settlement statement, deed of trust, and other loan or conveyance documents, and the closing attorney's receipt of all funds necessary to complete. Settlement, every single one of us in this industry use the term settlement wrong, and you will too, trust me. We all run around talking about going to closing. We're going to closing, we're going to closing. The truth is, in my 20 years, I have never once attended closing. Technically, what we do is attend settlement. Settlement is when buyers and sellers are getting their signed documents to the attorney. The loan package, the deed, whatever else is required. The attorney is collecting the buyer's money, whatever money they have to bring to closing. If the seller's underwater, then the attorney's going to collect that money from the seller as well. That is settlement. We're going to define closing in just a second. The settlement date, the parties agree that settlement will take place on this date unless otherwise agreed in writing in a time and place designated by the buyer. So the settlement date that we're putting in here is usually different than the end of the due diligence. How long in between? Completely negotiable between the parties. Settlement date is the date that we're all aiming to go to the attorney's office to sign the documents necessary for the attorney to do closing, which we'll talk in just a second. You will note as well, there is not a time being of the essence associated with the settlement date. Delays just happen. They just happen. As we see in this form later on, we got a built-in delay built into the offer to purchase and contract. So we'll see that in just a second. Questions on settlement? So we go to the attorneys. Everybody does their thing. We leave the attorney's office. The attorney does closing. Closing is defined as the completion of the legal process, which results in the transfer of the title to the buyer from the seller, which includes the following steps. First off, settlement, which we defined above, the completion of satisfactory title update, closing attorney's receipt and authorization to disperse all funds. That's our settlement statement, the ALTA we looked at last week. And the very last step, the very last thing that happens in closing is recordation in the appropriate county registry for the deed and deed of trust, if any, which shall take place as soon as reasonably possible for the closing attorney after settlement. The very last act, the very last thing that happens is the attorney records the new deed and deed of trust if applicable. Then and only then is it a done deal. So we all leave the attorney's office. The attorney puts their finishing touches on everything, records the deed. Now it's a done deal. Most of the time, settlement and a closing happen on the same day. Most of our attorneys are scheduling settlement like no later than 3 p.m. So they have time to get everything done and get the deed recorded before the register of deeds closes at 5. But if anything gets held up, if something comes up that prevents the attorney from recording the deed today, then closing and settlement are not on the same day. And regardless, the buyer should not get access to the property. We'll see this in just a second. The buyer should not get access to the property until that new deed is recorded. It's not theirs until the deed is on record. Does the internet go down sometimes? Does Spectrum go down sometimes? What if the attorney's trying to record the deed and the internet's down? Could that delay closing? Absolutely. What if the buyer forgot to initial something in their loan packet and the lender's not releasing the funds until they get that initial? Could that delay closing? Yes. So I don't want to tell you guys that nothing can happen between settlement and closing, because stuff does happen sometimes. I have zero control over Spectrum. Zero. The internet goes down, nothing I can do about that. This is why we always want to make sure our people have a plan B. Even if they're sitting at the closing attorney's table signing, it's still not done. Make sure your buyers and sellers understand that. Upon closing, the proceeds shall be dispersed by the closing attorney, and according with the settlement statement and the provisions of this general statute, don't need to know that. If the title update should reveal any unexpected liens, encumbrances, or title defects, or if the attorney is not authorized to disperse all closing funds, then the closing shall be suspended and settlement deemed delay under paragraph 12, where we define the delay in settlement. So we'll get to that as well. Here is our first big red warning. The North Carolina State Bar has determined that the performance of most acts and services required for a closing constitutes a practice of law and must be performed only by an attorney licensed to practice law in North Carolina. State law prohibits unlicensed individuals or firms from rendering legal services or advice. Although non-attorney settlement agents may perform limited services in connection with the closing, they may not perform all the acts and services required to complete at closing. A closing involves significant legal issues that should be handled by an attorney. Accordingly, it is the position of the North Carolina Bar Association and the North Carolina Association of Realtors that all buyers should hire an attorney licensed in North Carolina to perform a closing. So remember last weekend, we talked about different meeting methods. Other states use an escrow meeting method that doesn't involve an attorney. We are one of the few that uses a settlement meeting method state. We are one of the few that uses closing attorneys. So when your buyer moves in from another state and looks at you and says, do I have to hire an attorney? Your answer is, yeah, you do, because we're a settlement meeting state and because the contract says so. A question came in about the closing disclosure. I'm thinking you're referring to the 3-day rule. I've not seen many delays because of the 3-day rule. What I am seeing, I hate to say this, is lenders are sending out over exaggerated numbers. Is that a nice way to put that? Over exaggerated numbers. So they're in compliance, and then we can finalize. That's another reason why we're telling our buyers, don't go to the bank when you get the CD from your borrower. You wait and go to the bank till after you talk to me, because that's the final. All we're trying to do in that 3 days is be in compliance so we can close. So I've personally not had one delayed because of that rule, but I know it happens quite a bit. But I think lenders have found a way around that by just kind of putting stuff in there, and then we'll finalize it before settlement. Other questions about settlement, closing? I'm still not done defining things. I told you the first 2.5 pages, it's like reading the dictionary, isn't it? Good times. The last thing we have to define in this first provision is special assessments. This was changed in July of 2021 a little bit as well. We'll talk about those changes when we get specifically to buyers and sellers. Right now, we're just defining a special assessment, a charge against the property by a governmental authority, in addition to ad valorem taxes and reoccurring government service fees levied with such taxes or by owners associations, in addition to regular assessments, either of which may be a lien against the property. So special assessments in our contract is covering government special assessments. Maybe the government is doing an improvement on the neighborhood. Maybe the city's going to install street lighting in the neighborhood or sidewalks, and they put a special assessment on the neighborhood. The homeowners would pay part of that through a special assessment. You may also have a special assessment by an owners association or an HOA. Maybe they want to replace the roofs in a condominium complex, for example. So special assessments. And again, we're going to talk about, and that's what our blue note is saying, buyers and sellers' respective responsibility are spelled out later in the contract. So we'll talk specifically about buyers and sellers. Questions on the first provision? There's some good information in there. There's some good information in that first provision. Our second provision are fixtures and exclusions. Starts with big red warning. Parties should not assume, I hate the word assume, never assume anything. Parties should not assume that an item will or will not be included in the sale based on an oral or written statement or understanding that is not part of this contract. Buyer and seller should be specific when negotiating what items will be included or excluded from the sale. Fixtures and personal properties is what puts people in court. Fixtures and personal properties when buyers and sellers start suing each other after the fact. So that's why we have this big red warning, all caps, all bold. Can you see it? Does it pull it out? I don't know, another thing they could do to make it stand out any clearer. Be clear. When you're negotiating fixtures and personal property, be clear. Fixtures are included in the purchase price. All existing fixtures are included in the sale as part of the purchase price, free of liens, unless excluded below. Specified items, buyer and seller agree that the following items, if present on the property on the date of the offer, shall be included in the sale as part of the purchase price, free of liens, unless excluded below. All items below include both traditional and smart versions and any exclusively dedicated related equipment and or remote control devices. So the smart versions just made their way into our contract July of 2020, because our homes, some of our homes are smart now. Some of our homes are kind of scary about how smart they are. But any smart features are now included in our contract. We'll see that again in just a second. And then we have a nice little handy dandy list of fixtures. Again, every time there's a lawsuit, there's a new fixture that pops up in the list. July of 2021, new to our contract list, they added thermostats. Are you telling me that this means that somebody moved out and took the thermostat with them and the buyer sued them and now the thermostat's in the fixture list? That's the way I've always understood how they wind up there. And this
Julie,
might have smart thermostats too, instead of my old school one where I walk up to the wall. Yeah, Robert.
I was gonna say, are some of the newer thermostats not glued, screwed, or nailed, I guess?
And that's probably where they're addressing, because if you have a smart thermostat, if you can sit on your couch and adjust your heat or your AC, I guess I'm still old school. I got to get up and walk across the room to adjust my heat. But if you can sit on your couch on an app on your phone, then I think that's more that why that was added, to clarify. Anything on this fixture list though, guys, this very same list, word for word of this fixture list also shows up in our listing agreements. So listing agents, when you're at the listing appointment, you can have this discussion with your seller. Is there anything on this list you plan on taking? And if the seller says, yeah, this, when we got married, the mailbox was a wedding gift, so we want to take our mailbox with it. Great, fantastic, take your mailbox. I need you to go out and get another mailbox. I need you to replace, right? Buyers expect a mailbox. Ideally, I want my seller to replace the mailbox before I ever market the property and buyers show up and see it. Because we know how people are, right? As soon as you say this mailbox won't convey, people are going to get, well, I would have bought this house if that mail, but since that mailbox isn't coming, I'm not going to buy that house. You know how people are. So if they never see it, then they can't want it, right? So ideally, we can try to have our seller take down any fixtures and replace it with something comparable to that space, something that looks nice in that space before buyers ever show up. If, however, the seller refuses, maybe they're worried that it'll bring bad karma to their marriage if they take the mailbox down, if they don't get mail as a married couple in this mailbox, maybe they have that belief. It becomes my job as a listing agent to make sure that every buyer that sees this property, every buyer with an interest know that this mailbox will not convey. I need to put it in my agent only remarks, maybe put a note in the kitchen. Don't forget, mailbox doesn't convey. You guys with me? Every single buyer that sees this property needs to know that when they show up after closing, that mailbox will not be there. That particular mailbox will not be there.
Hey, Julie, I have a quick question.
Yeah.
Up there under the storage sheds and utility buildings, those that are the Rubbermaid type, I'm assuming that's not what they're including in that, because they're typically not glued, screwed, or nailed, which is what I was taught in pre-licensing was a fixture is glued, screwed, or nailed.
Unless it's addressed here. So what does the contract say? The contract says storage sheds. So this is why we say if there's any doubt, and Robert, I absolutely hear what you're saying. So if there's any doubt, it's best to clarify it in the contract. Okay. So if a buyer could look at that and say, well, it's a storage shed and the contract says storage shed, then you would want to make sure as the listing agent that your buyers, just in case, your buyers know that that's not the seller's not going to leave it. Right.
Gotcha.
So this is where communication, because we could spend days looking and pointing at different things, right? And this is up for not for debate, but you could see both sides of it in some cases. So if that's the case, something like that, if there's any uncertainty whatsoever, put it in the contract so we're all clear. We all know we're on the same page. And again, I address this with my sellers before I ever list the property. My sellers say, oh, thank you. We'll look at this tonight before we go to bed. You know what? I'm a really patient person. I can sit here for 5 minutes while you look this over. And then just be quiet for a minute and let them look it over. Because I need to have a discussion with them before we ever list the property. Everybody with me? Know what's going on. If they're going to take any fixtures, know what's going on. I would recommend somewhere between now and tomorrow afternoon, you look over this list of fixtures. Okay. All right, tomorrow afternoon. We know what we're doing tomorrow afternoon. Okay. We have verbiage on pairing, deleting data from devices. Again, this is new to address our smart homes. Prior to closing, sellers shall unpair any devices that will convey from any personal property devices. It specifically mentions hubs and intelligent virtual assistants, mobile devices, vehicles, etc., with which they are paired. Delete personal data from any devices that will convey and restore all devices to factory default settings unless otherwise agreed. Seller's obligation under this paragraph 2 shall survive closing. Our blue note says any fixture or other item described in paragraphs below will not be part of the sale and should be identified on paragraphs. Yep, I'm on page 3. Items leased or not owned. If these are fixtures that the seller doesn't own, then they can't convey them. You can't convey what's not yours. So if it's leased or not owned, it goes on to say any item which is leased or not owned, such as fuel tanks, antennas, satellite dishes, receivers, appliances, alarm and security system, shall be identified here and shall not convey. Again, listing agents, have a conversation with your sellers. Oh, you have security cameras. Do you own that equipment or is that leased from CPI? Right? Use the forms to help you. Use the forms to help you when you're going through the home. This is the section where we put any fixtures, following items shall not convey. Remember, a fixture's intent is to stay. So if a seller's going to take it and a buyer can see it, then we need to spell it out here. The mailbox, the antique chandelier in the dining room, whatever fixture the seller's going to take that they haven't removed yet. Again, in a perfect world, they're going to take it down before I ever list the property. We, however, are not in a perfect world. So if there's still anything, and then there's a little section here, seller shall repair any damage caused by removal of any items excluded above. So when they rip the chandelier out of the dining room ceiling, they need to replace any, repair any damage. Ideally, they're going to put up a new something in the dining room, whatever looks nice in that space. Don't leave me with a light bulb on a string, right? Put something else up. Go to Lowe's, get a chandelier. The opposite of fixtures, personal property. A fixture is supposed to stay, a personal property is meant to go. If they're going to do the opposite of their intent, if a fixture is going to go, a personal property is going to stay, then we put it in the contract. Or as Robert said, if you have items that are just up for debate, when in doubt, fill it out. When in doubt, just put it in, be clear. So the following personal property present on the property on the date of the offer shall be transferred to the buyer at closing at no value. We need to be specific when spelling out personal property. I've always heard the story. I don't know if this is true or not, but it sits home, doesn't it? The buyer asked for refrigerator. That's all they said, refrigerator. We go on to closing. They get their keys. They show up at the property. And in the kitchen, where the big refrigerator should be, is a 2-shelf dorm room fridge. Did the seller do what they were contractually obligated to do? Did they leave a refrigerator? Yeah. Is the buyer happy? No. Be specific. 2-door stainless steel Whirlpool. Sometimes you can open when you open the doors, you can see a model number on the inside cover. I caution you from saying stuff like the refrigerator that was present on the property, the date of the showing. Because who's going to prove what refrigerator was present on the property, the date of showing? You with me? You may want to take a picture just for documentation, but I would still spell it out here. Because remember what we said about the parole evidence rule? The final written word will prevail. So just be cautious. I've seen that a lot. The refrigerator that was there when we went under contract. Well, okay, that's now my word against yours. How's a judge going to prove that? Y'all want to know the personal best that I ever put in for personal property? I actually got to I put this in a legally binding document. Adams Family Value pinball machine. The sellers had like a little finished basement with he had it set up as a game room. And we walked downstairs and my buyers were like, oh man, they got a pinball machine. We want that. So anything's negotiable. So y'all want me to put it in? They said we did. You know what the seller said? Oh, thank God, we didn't want to move it anyway. Yes, it's yours. I've never moved a pinball machine, but the sellers made it seem like that's no easy, easy feat. So it was a win-win. And I now am on record of having a legally binding document that says Adams Family Value pinball machine. Not just any pinball machine, but I specifically want the Adams Family Value. Blue note says any personal property that would be part of the sale should be identified in this paragraph. Buyers advised to consult with their lender to assure the personal property items listed above can be included in this contract. Y'all please note that last sentence here. Remember, the lender is issuing the loan to purchase real property. They're not issuing the loan to purchase stuff. So usually the refrigerator's okay. Washer, dryer is probably the second biggest personal property. When your buyer when they start rattling off, well, I want the dining room set and I want the living room set and I want the car and the garage. When this personal property list starts growing, buyer's agents, we need to just make sure it's okay with the lender and the loan. You may be best to negotiate doing an outside bill of sale where the buyer would bring like a cashier's check, for example, to pay for the car in the garage and not running the car through the offer to purchase and contract. But again, just get with your BIC and get with your lender. If you've been out showing property, you don't have to be out. You don't have to show too many properties to have a buyer walk in the garage and go, ooh, that's a nice car. Does it come with the house? And I always say, anything's negotiable. Comments or questions on fixtures or personal property? Okay, where are we now? We're on page 5. So I think I might have told you wrong earlier. Fixtures list is on page 4. Again, I would look that over before tomorrow. I mean, right, nod, wink, wink, right? Okay. I really don't know another way to say that, yeah. Okay. Provisions 4, 5, and 6 are about the buyer. So if you're a buyer's agent, you want to make sure that you're specifically, in addition to everything in the contract, but provisions 4, 5, and 6 are specifically about the buyer. So provision 4 is the buyer's due diligence process. We have a big red warning. Buyer is strongly encouraged to conduct due diligence during the due diligence period. If buyer is not satisfied with the results or progress of their due diligence, buyer should terminate this contract prior to the expiration of the due diligence period, unless the buyer can obtain a written extension from the seller. Please note, seller is not obligated to grant an extension. If you need more due diligence time, we can always ask. But the seller is under no obligation to extend due diligence. The worst they can do is say no. Although buyer may continue to investigate the property following the expiration of the due diligence period, buyer's failure to deliver termination of the seller prior to, the expiration will constitute a waiver by buyer of any right to terminate this contract based on any other matter relating to buyer's due diligence. I want to talk about that sentence for 1 second and make sure we're good. When due diligence is over, buyer has not lost their right to inspect and investigate the property. They keep inspecting and investigating up till the final walkthrough on our way to the attorney's office. When due diligence is over, they can keep inspecting. The only thing they lose when due diligence is over is the right to terminate. The only thing they lose is the right to terminate. Guys, the buyer's not considered in breach until after due diligence. That's when the buyer's in breach. We'll see that remedy in paragraph 23. After due diligence, the seller agrees to do any repairs. The buyer can have those completed repairs checked. They can have those inspected. We're going to talk about the final walkthrough in a minute. The buyer can keep learning. They can keep inspecting and investigating. Even when due diligence is over, it's not like at 5 p.m. today. Oh, well, that's all I need to know. They keep going until settlement. The only thing they've lost at the end of due diligence is the right to terminate. Everybody good with that? Do I have questions on that?
The right to terminate without breach, correct?
Say it again.
The right to terminate without breaching the contract.
The right to terminate, yep, for any reason or no reason. So after that, if they terminate for any reason, now they're in breach, and we'll discuss those consequences of breach. With the exception of seller breach. Where am I? Provided, however, following the due diligence period, buyer may still exercise the right to terminate. Here we go. If the seller fails to materially comply with any of the seller's obligations, we'll get to seller's obligations in just a second. And then it goes through and lists some of the things that the buyer should consider inspecting and investigating during due diligence. We've already talked about a lot of these, so we're going to kind of boogie on through this section because we discussed this in chapter 14 last weekend. I do want to point out, please remember, the loan process is the longest part of the contract to closing process. So make sure you're getting that loan going. Anything to do with the buyer's loan is going to be at the buyer's expense. And this note is reminding this is probably a problem topic right here. Buyer's obligation to purchase the property is not contingent on obtaining a loan. So if we find out after due diligence that the buyer's not going to get loan approval, the buyer has to terminate. The buyer's now in breach. They'll lose their due diligence and their earnest money. Can the parties agree to add a loan contingency? Absolutely. Absolutely. The parties can agree to anything. But what I need you guys to understand is if they don't agree to that, there is not a loan contingency. Everybody see that? It's not contingent on obtaining a loan. In all my years, I've only known one buyer to get the clear to close from the lender while we were still in due diligence. It's really, really rare to have the clear to close while we're still in due diligence. The best we can do usually while we're in due diligence is have the appraisal done and have the loan through the first round of underwriting. Once it comes out of the first round of underwriting, the lender can give us a pretty good idea. So based on that pretty good idea, which is not a guarantee, it's not an approval, it's a pretty good idea. And based on that, the buyer needs to decide if they want to move forward with or terminate the transaction, knowing that we don't have loan approval as we're leaving due diligence. Questions on that? Again, we talked about a lot of this. Inspections, home inspection, pest inspection, radon test, review of documents. If we're going in an HOA, we want to help our buyers get copies of covenants, bylaws, articles of incorporations. We want to make sure that the buyer obviously has received and reviewed the RPODs, Residential Property and Owners Association disclosure. We'll talk more about that in a minute. Homeowners insurance. We want to try to get that secured while we're in due diligence, make sure they can afford it. The appraisal, the survey, any zoning and governmental issues. Is there any proposed zoning amendments on the table? Road construction, school, flood hazards, if we're in a flood zone, utilities, streets and roads, help the buyer identify if they're public or private streets. Again, I'm not referring to whether or not you can drive on them. I'm referring to who maintains them. Public roads are maintained by NCDOT. Private are maintained by the owners that live on the road. So get them that information. Most lenders, if it's a private road, most lenders will require, there's another form that they'll require for more information on the roads. What else we got? Special assessments. We'll talk more about those in just a second. Fuel tanks. If there's fuel tanks on the property, buyers advised to consult with the owner of the fuel tank regarding the terms which the buyer may lease the tank and obtain the fuel. So if it's a leased fuel tank, have them call the company. Most of the time, they'll just allow them to do a transfer. They can keep the contents in there and they can just transfer the name from the seller to the buyer. You guys, please understand, this list is not inclusive. This is just a starting off point for the buyer. What should I investigate? What should I inspect? Again, use the words to help you put forms to help you put words in your mouth. Bottom line, if your buyer wants to inspect something or investigate something, our answer is okie doke, let's do it. We're not going to say, well, it's not on the contract, so we don't really have to do that. If it's important to my buyer, then it's important to me. If my buyer says I want to inspect or investigate this, I say, all right, let's do it. As we head to break, I leave you with another story. I was teaching a post licensing class a couple years ago. We were still in person. And this young lady, about this time, put her hand up. She said, my very first buyer ever. So I was so excited. I got my buyer. We were out working. Everything was going great. I found him a house and we got under contract. Once they were under contract and due diligence, her buyers called her and said they had been talking to this 1-800 fortune teller that suggested they take some kind of ceramic bunny and they put this bunny in the house, and based on what the bunny does or does not do, will tell them the vibes of the house, if it's good vibes or bad vibes. Her very first buyer ever. She calls her broker in charge and she was like, this is the craziest thing. What do I do? And her BIC said, you put the damn bunny in the house, because if it's important to your buyers, then it's important to you. And if it was important for them to determine what the ceramic bunny was going to do, and she said, okay. And that's what she did. And they were satisfied with the results and they went to closing. If it's important to your buyers, then it's important to you. 1-800 fortune tellers. All right, let's take 10. That's the thing about this industry. I don't have to make stuff up. This stuff actually happens. You know? So let's see, it's 11 now. Let's come back at 11:10. We'll keep looking at our contract. All right. We're doing good? Good. Still talking about, we're still on provision 4, which is the buyer's due diligence process. Sale or lease of existing property. As noted in 5B below, which we'll get there, unless otherwise provided in this addendum, in an addendum, this contract is not conditioned upon the sale or lease or closing of other property owned by buyer. Again, you guys, there's not a built-in contingency if the buyer has a property to sell or lease before they can buy this home. Can the parties agree to add this contingency? Yes, but it's not automatic. It doesn't just happen. With that being said, real quick, before I forget, I need you guys to turn to page 354 and 355. 354 and 355. 354 and 355 talk about a contingent sale addendum. That form is no more. They retired that form a couple years ago. That form no longer exists. So if buyer and seller agree to add a contingency, the contingency saying, I can't buy your house until I first sell mine, then they have to have an attorney draft that up. Why did they do away with the form? I'm getting ready to answer that in just one question and 1 minute. Answer that. You know what I'm trying to say. Answer that question in just 1 minute. Yes, I got you. Or you got me, I'm not sure. All right, so this contract is not conditioned upon a sale or lease or closing of other property owned by buyer. Therefore, if buyer must sell or lease other real property in order to qualify for a new loan or otherwise complete this purchase of this property, buyer should seek to close on buyer's other property prior to the end of due diligence period, or be reasonably satisfied that closing on buyer's other property will take place prior to the settlement date of this contract. The reason they did away with the contingent sale addendum is because that's part of the buyer's due diligence process. So if they can't close while they are still in due diligence, then they need to try to be reasonably satisfied that closing is going to happen. If we find out after due diligence that the buyer can't sell their home, the buyer has to terminate and they're in breach. So which by the way, due diligence, I bought my condo in 2006 and we didn't have due diligence yet. So due diligence just came, I want to say 08, 09, somewhere in there, like, yeah. So it's not overly old. Don't write that date down, but we're still fairly new to due diligence in this state. We didn't have it at one point. And once upon a time ago, when you didn't have due diligence, the contingent sale addendum, but now the suggestion is that the buyer seek to close while they're in due diligence, make that part of their due diligence period, or be reasonably satisfied that it's going to close. Comments on that, questions? And in this market, by the way, this is not happening. If you got 40 offers in your hand and one of them is offering a contingency to, I got to sell my house before you can buy yours, you pretty much reject that one pretty quickly in this market, don't you? Repair improvement negotiations agreement. Buyer acknowledges and understands that unless the parties agree otherwise, here it is, in my opinion, the most important sentence of our whole 15-page offer to purchase and contract. This property is being sold in its current condition. Is the seller under any obligation to do any repair? Do they have to fix a thing? Do they have to change a light bulb? No. Why? Because this property is being sold in its current condition. Buyer and seller acknowledge and understand that they may, but are not required to, engage in negotiations for repairs and improvements to the property. Buyers advised to make any repair improvement requests in sufficient time to allow repair improvement negotiations to be concluded prior to the expiration of the due diligence period. Any agreement that the parties may reach with respect to repairs or improvements shall be considered an obligation of the parties and is in addition to this contract must be in writing and signed by the parties in according to paragraph 19. Remember what we said last weekend? Any agreed upon repairs have to be in writing and signed by the end of due diligence. Any agreed upon repairs have to be in writing and signed by the end of due diligence. The repairs themselves don't have to be complete until prior to settlement. Comments on that? Questions? Is that? This is the sentence that's making buyers so mad right now. But I put down 100,000 due diligence. I used to have a BIC. The man was really intelligent and he was really good about making us think for ourselves. And sometimes that's aggravating because I don't want to think for myself. Just give me the answer. So you call him in a panic. What do I do? What do I do? And you know what his number one answer? Always, every single time. And dang it, he was always right. What does the contract say? Because more often than not, the answers, my buyer's upset because he's losing $100,000 due diligence. What does the contract say? Everybody with me? Yet another good plea for me to say it's important that we understand what the contract says. And I know what the contract says. That's not why I'm calling you. Why can't you help me? And he would, don't get me wrong, he would, but that was just because he's right. He was right. The answer lies within here somewhere. Buyer's obligation to repair damage. Buyer shall, at buyer's expense, promptly repair any damage to the property resulting from the activities of buyer and buyer's agents and contractors. But buyer shall not be responsible for any damage caused by accepted practices, either by the North Carolina Home Inspector Licensure Board or applicable to any other North Carolina licensed professional performing reasonable appraisers, tests, surveys, examinations, and inspections of the property. This repair obligation shall survive any termination of this contract. To sum it all up, if the buyer's home inspector damages the property, the buyer's on the hook to pay for that. The buyer's responsible for damage caused to the property through their investigation and their inspections. This does not include any accepted practices by, for example, the North Carolina Home Inspector Licensure Board. One of the things that always just makes me laugh, when you see a home inspection report, your home inspectors, they take lots of pictures. So don't get excited, you got a 60-page home inspection report. There's probably lots and lots of pictures in there. And if the home inspectors detect rotting wood, maybe soft wood around a window or a door frame, they're going to take their screwdriver and they're going to jam it in the wood and they're going to take a picture of it. The home inspector did not damage the property. The home inspector is showing that the property was damaged. If that was soft wood, their screwdriver wouldn't stand straight up. So there's the difference in the home inspector damaging the property or an accepted practice by the North Carolina Inspector Licensure Board. They're just showing, look, this wood is soft, the screwdriver stands straight up. And this last sentence, repair obligation shall survive any termination of this contract. So if the home inspector damages the property, the buyer terminates, the buyer's still on the hook to repair it. Just because they terminate the contract doesn't mean that they're no longer obligated to repair it. Indemnity, if you're indemnifying somebody, you're holding them harmless. So buyer will indemnify and hold seller harmless from all loss, damage, claim suits, or costs which shall arise of any contract, agreement, or injury to any person or property as a result of any activities of buyer and buyer's agents and contractors relating to the property, except for any loss, damages, claim suit, or costs arising pre-existing conditions and or out of seller's negligence or willful acts or omissions. Again, this indemnity shall survive the contract. We see, I'd say this is boilerplate. We see a similar verbiage in the sellers section as well. We also have a section in just a bit that says if we do have to take each other to court, we're going to try and hash it out in mediation first. So it's just kind of that legal, what if we got to go to court? Who's responsible for what? Buyer's right to terminate, provided that buyer has delivered an agreed upon due diligence fee. Buyer shall have the right to terminate this contract for any reason or no reason by delivering to seller written notice of termination during the due diligence period. Once again, we're reminded, time being of the essence. If buyer timely delivers the notice, this contract shall be terminated and the earnest money deposit shall be refunded to the buyer. Again, written release of both parties. If the seller refuses to sign the written release, the buyer takes them to the clerk of court, small claims courts. The judge reads that sentence and they say, well, of course the buyer gets the earnest money. Why wouldn't they? The written notice that the buyer has to deliver to the seller if they exercise their right to terminate. We got termination forms. We don't cover those in this class, but there's termination forms, termination with release of earnest money, termination without release of earnest money. The written notice just has to notify the seller that they're terminating. The buyer doesn't have to tell the seller why they're terminating. They can choose to. It's up to them if they want to. All they have to do is just provide written notice saying I'm terminating. And then lastly, for the buyer's due diligence, closing shall constitute acceptance of the property in its then existing condition unless provision is otherwise made in writing. Congratulations, Mr. Buyer. Here are your keys. The house and all its problems are now yours. Congrats. This is why this last sentence right here is why the final walkthrough is so important. Because what they're signing at settlement, they're signing acceptance of the property. So if we don't do the final walkthrough, how do they know what they're signing? And this is the hard reality. What if we do the final walkthrough? We've never seen this home vacant. It's been occupied the whole time we've been in there. And we never see this home vacant. And we do the final walkthrough and we realize the reason that there's a picture here is because it's hiding a big hole in the wall. And we see that the reason why the couch was there was because the carpet's torn up, right? What if we're seeing this home vacant for the first time and it's a mess? The buyer pretty much either has two choices. They either go on to the attorney's office and sign and accept the property the way it is, or they don't. They need to understand, if we go to the attorney's office and they sign, they are accepting it. Now, if they don't, maybe we call the seller and say, well, what's up in here? You know, maybe it's not over yet. But bottom line, you guys, if the buyer's not satisfied with the property in the final walkthrough, they have two choices. We may not always like our choices, but we almost always have two choices. Either you go and sign or you don't. Comments on that? By the way, I'd be on the phone with the listing agent before I was back in my car. That's, you know, but anyway, yeah, Robert.
Yeah, I was actually writing notes and you may have covered this while I was writing. I apologize. So on the final walkthrough though, that's their opportunity also to check on negotiated repairs that had been made. And if those particular repairs hadn't been done, they still have basically a leg to stand on.
That's right. And they can check on those repairs prior to final walkthrough if they want, right? So if the seller finishes last week, we can go last week and then still do the final walkthrough. So yes, if the latest you have, if they just finished yesterday and the final walkthrough is now when you're just now seeing them and they're not happy with how the repairs were done, they have two choices. Even though we have it agreed upon, if the repair was done, just because it's not up to the buyer's satisfaction, you with me? They still have two choices. They either sign or don't sign. Yet another reason why we need to have our buyers have a plan B. I can't think of anything in this world that makes me more nervous than when the buyer starts talking about coming to the attorney's office in a U-Haul. I get scared. I'm like, what does that mean? If we don't close today, where are you sleeping tonight? Do you have enough room in that U-Haul? Right? So always encourage them to have a plan B. Stuff happens. What's going to happen? I don't know. I don't have a crystal ball, but I know stuff happens. Other comments on that? We address the final walkthrough in the contract in just a minute as well. The fifth provision is buyer's representations. Remember, you guys, our contracts are a bilateral contract. How many parties have duties and obligations to perform in a bilateral contract? You can show me on your hands. Yeah, two parties have duties and obligations. So buyers make representations to the sellers. The seller should be able to rely on this information when deciding if they want to enter into a contract with this buyer. So it needs to be complete and accurate. We have seller representations as well. First thing the buyer has to represent is, how am I going to buy this house? What kind of funds am I going to provide? If it's a cash buyer, buyer intends to pay cash and does not intend to obtain a loan or funds from sources other than the buyer's own assets. If buyer does not intend to obtain a loan, sellers advise prior to signing to obtain documentation from the buyer, which demonstrates the buyer will be able to close on the property without the necessity of obtaining a loan or funds from sources other than buyer's assets. It's as simple as your cash buyer calling their bank and requesting a proof of funds letter. I don't need to know everything they have in their savings account. What I need to know is, do they have enough? Is the bank willing to verify that they have enough to purchase the property? So I'd want at least the purchase price and probably a little extra more for, inspections, due diligence, earnest money, that kind of thing. I had a buyer once, I talked about proof of funds, and evidently I didn't do a good job because my girl went to her bank account, logged on and printed off her, just when you log onto your bank account and you see your, she just hit print. She handed, I don't want to see that. I don't want to see that. What I want to see is a proof of funds, somebody from your bank saying, yep, she's got the money there. Back to our delay. If they're not going to sign at settlement, yep, they got 7 days, and we're getting to that, to our built-in delay. Yep, 7 days delay. So again, there's a big hole in this wall that I never saw because this picture was here. It's not over. I just don't want to sign until I know the seller's going to fix this hole, right? So maybe now at this point, we're sitting in an attorney's office. So if we agree we're going to go on to closing and the seller's going to fix it afterwards, we can have an attorney draft something up real quick, right? Because now we're sitting there in front of one, getting this hashed out. So please don't understand, hole in the wall, I'm not signing. It ain't over yet. I'm just cautioning my buyer not to sign with this hole in the wall, because once they do, that hole in the wall is now their problem. Is everybody good with that? And the seller says, I don't care, it's just a hole. Fine, sign here, right? As long as they understand those consequences. So cash buyers, we want proof of funds. Or if your buyer's getting a loan, buyer tends to obtain a loan. First mortgage and the amount of how much, is it FHA, VA? If it is FHA or VA, again, we're instructed to include the FHA, VA financing addendum. That's one form that we'll look at when we're done. Conventional USDA. Second mortgage loan. Maybe they need 2 loans to purchase the property. Again, it's all about the buyer representing to the seller how they're going to purchase this property, how they're going to have the funds available to do it. Once again, we're reminded in a blue note, buyer's obligation under this contract are not conditioned upon obtaining any other loan or funds from sources other than buyer's own assets. Some mortgage loan programs and other programs providing funds selected by buyer may impose repair obligations and or additional conditions or costs upon the seller or buyer, and more information may be needed. It's one thing we're going to see in the FHA VA financing addendum. The VA will require the buyer to get the pest inspection. Very rarely do they let the buyer pay for it. So if it's a VA loan, the seller is going to be on the hook for paying for that pest inspection. So listing agents, When that offer comes in on a VA property, we need to have that discussion with our seller. We'll see that in our FHA VA financing addendum. Although it's not contingent, the buyer has to represent that they do or do not have to sell or lease another property in order to qualify for a loan. So it's not a contingent, it's not a contingency, but they still have to represent if they do or not. If they do, they're going to put in their property address. And then they're going to select, if applicable, buyer's other property is under contract as of the date of this offer. Copy of the contract has either been provided to the seller or accompanies this offer. So if you have another property to sell, you want to present your offer with this offer. We're told that we can mark out any confidential information, so get out your black Sharpie, such as purchase price, buyer's identity, etc. Failure to provide a copy shall not prevent this offer from becoming a binding contract. However, listing agents, your seller is strongly encouraged to obtain and review the contract prior to accepting this offer. So if they have to sell a property before they can buy this one, we need to provide the seller with that information. So buyer's other property is under contract or buyer's other property is not under contract. If it's not under contract, we're going to select one of the below. It is listed and actively marketed. It will be listed and actively marketed, or the buyer's attempting to go on their own, also known as for sale by owner. So if I'm making an offer on your home and I have a property, I got to tell you, is it under contract? Is it listed? Is it not listed? It's all about representation. Our blue note reminds us this contract is not conditioned upon the sale or lease of buyer's other property. If the parties agree to make this contract conditioned on the sale or lease, then an appropriate contingency addendum shall be drafted by whom? A North Carolina real estate attorney and added to this contract. Again, the contingent sale addendum, I don't remember when, but it died a couple years ago. So now if we want to have a contingency, what's the contract say? An attorney should be notified to draft up a contingent sale addendum. Performance of buyer's financial obligations to the best of the buyer's knowledge. There are no other circumstances or conditions existing as of the date of this offer that would prohibit a buyer from performing buyer's financial obligations. What if the buyer was possibly facing bankruptcy, for example? They would need to want to disclose that. Let the seller, again, the seller needs all the information when they're trying to decide to enter into a contract with this buyer. So if there's something else that may prohibit them from purchasing this home, they should disclose that. Buyer needs to represent whether they have or have not received the RPODs and the MOG. So buyer has received a signed copy of the RPODs prior to signing this offer. Buyer has not received a copy prior to signing this offer. And I'm sorry, what does that say? Shall have the right to terminate or withdraw without penalty, including the refund of due diligence fee, prior to whichever the following occurs first. Either the end of the third calendar day following receipt of the disclosure or the end of the third calendar day, the effective date of the contract. So if for some reason you're presenting an offer on behalf of your buyer and you haven't seen the RPODs yet, it's not going to prevent us from entering into a contract. But the seller still has a duty to provide that. Mandatory form, optional disclosure. So we go under contract, the seller still hasn't provided it. The buyer has an out. They can terminate, get their earnest money and their due diligence back. Please understand, mandatory form, optional disclosure. The buyer does not have the right to terminate if the seller says no representation. They don't have the right to terminate because they don't like how the seller completes it. They only have the right to terminate because the seller doesn't complete it. Everybody good with that? That's the seller's right. That's the caveat emptor to say no representation. The buyer probably isn't going to like that, but that's not their right to terminate. Their right to terminate is because they didn't receive mandatory form, optional disclosure. The other thing here that would negate this is if the buyer's already living there. So maybe it's been a tenant for years and years and years, and now the landlord's selling to the tenant, for example. We don't need a residential property disclosure. So there is a possible out, buyer's agent, there is a possible out for your buyer if you've not received it. And our third option here is the list if the RPODS is exempt. And again, we're directed to go to the guidelines for completing the offer to purchase and contract that lists reasons why the RPODS might be exempt. Probably the number one reason is if the property is new construction. Never before lived in dwelling. The RPODS is exempt if the property has never been lived in before. So if that's the case, you just fill that in. And then we go through a similar exercise with the MOG. Buyer has received it, buyer has not. If not, then they have an out, either 3 days of receipt or 3 days of the effective date. New construction is not an exemption for the MOG. So new construction properties should include the MOG. If the seller has severed the mineral or oil or gas rights, or if they intend to sever the mineral or oil or gas rights, the parties are advised to consult with an attorney prior to signing this contract if severance of mineral or oil and gas rights have occurred. So another note reminding us to call your attorney or their attorney. 6 is the buyer's obligations. Buyer shall take titles. First off, about responsibility for special assessments. Buyer shall take title subject to all special assessments that may be approved following settlement. So if there's any special assessments still under discussion, we haven't voted a final aye yet. Anything that's approved after settlement, the buyer is responsible for paying. Now we'll see the seller's obligations and responsibilities with special assessments in just a minute. But the buyer's responsible for anything that's voted aye after settlement. Do you guys hear that? Okay, good. Good. I was going to go fuss at my husband. I think he's in there watching Red Dawn. And I just heard the, if I need to tell him to turn it down, I'm happy to do so. Y'all just let me know. All right, responsibility for certain costs by the old Red Dawn, by the way, not the new one. Let me be very clear about that. Okay. Buyers shall be responsible for all costs with respect to. They're responsible for their certain costs, the whole contract to closing process, any loan, anything about the buyer's loan, they're responsible for those costs, determining restrictive covenants, appraisal, title search, title insurance, closing attorney fees, recording of the deed. So it just spells out their costs, buyer's obligations. And then authorization to disclose. Buyer authorizes the lenders, the agents, me and you, closing attorneys, whomever, to provide this contract to any appraiser employed by the buyer, to release and disclose any buyer's closing disclosure, settlement statement, and or disbursement summary, or any other information to the parties this transaction, the agent of the lender. So you go into contract, you send the contract to the lender. Eventually, the lender orders the appraisal. The lender will send a copy of the contract to the appraisal. to the appraiser, excuse me. What gives the lender the right to send the buyer's contract to the appraiser? This paragraph right here. Anybody that needs the contract to do their job to get us to closing, the buyer's authorized that information to be released. 4, 5, and 6 are about the buyer's due diligence, representations, and obligations. Any questions on the buyer's piece of it? Provisions 7 and 8 are about the sellers. So listing agents, these are the discussion we want to have with our sellers. Make sure they're good with their piece of it. First thing the seller has to represent is their ownership. How long have they owned the property? They've owned the property for at least 1 year, for less than 1 year, or they don't yet own the property. First off, who's the buyer typically that owns a property for less than 1 year? Typically, who's that buyer?
You mean seller?
Yeah, I'm sorry. You know
Yeah.
what I mean. Who's that seller? Thank you. That owns a property for less than 1 year.
Investors.
An investor, a flipper, somebody who's buying it, buy
Or-
it, flip it, turn around and sell it, right?
Or
Typically.
someone who inherited it.
Or inheritance, yep. But typically, talking about flippers, most lenders don't mind flippers, but they still have to represent. Some lenders may have a flag go up when they see an investor, when they see that the property is flipped. FHA rules have rules for investors. So if it's an FHA loan, that's what we're asking for here. If they've owned it for less than a year, it's just kind of notifying the lender as it may pertain to that loan type. Does not yet own the property. Well, how can you sell something that's not yours? Isn't that interesting? I think the best example I've heard of that I don't know for this is if a builder is buying a land to build on the land and turn around and sell it as a package deal. So the builder's buying the land, they're going to build on the land, and they already have a buyer that they're building this house for. The seller, the builder, might still be in process of purchasing the property. So that would be a reason for them to disclose they don't yet own it. Once they get it, they'll build on it and then package deal back out to the buyer. Buyer represents if the home was built prior to what year? See, y'all don't need the contract to tell you that. You guys know that. You got that embedded in your mind, don't you? 1978. I love it. I saw all your mouths go. 1978. Property is built prior to 1978. Once again, we're instructed to attach the lead-based paint or lead-based paint hazard disclosure addendum. We'll look at that one briefly when we look at our forms. Seller authorizes and directs any owners association, management company, insurance company, and attorney previously worked with the seller to release to the buyer copies of the following affecting the property, including any amendments. So here, pretty much what you have are HOA documents, subdivision, community, neighborhood, anything like that. I think it's important that we point out, once again, you guys, this very list shows up in our listing agreement. So listing agents, this is a conversation we can have with our sellers before we get to the offer to purchase and contract. Back in the day when we're listing the property, we talk about fixtures, and now we can talk about any owners association paperwork, documentation as well, because a good buyer's agent is going to ask for it. So we can get our sellers to start gathering it now before those buyers show up. If it's in an HOA, then we're going to specify the name of the association. Dues are X amount per, is that per month, per year, per quarter, however the dues are spelled out. We want the information, the contact HOA information. And some places have two associations. Maybe one is mandatory and one is optional, for example. Maybe the mandatory is for the common areas and the optional is for the pool. So if there's more than one association, more than one due, we want to list those out there. Provision 8 are the seller's obligations. Seller's biggest responsibility is to provide marketable title. That's their biggest obligation. Their biggest duty is to provide marketable title. So evidence of title payoff statement, non-foreign status. Seller agrees to use their best effort to provide the attorney as soon as reasonably possible after the effective date, copies of all title information in possession of or available to the seller, including but not limited to title insurance policies, attorney's opinions, surveys, deeds, notes, deeds of trust, leases, easements, etc. Basically, if the attorney needs anything from the seller, the attorney's going to get in touch with the seller. If the attorney finds anything on the title that could impact transfer of title, the attorney will get with the seller. The attorney will work with the seller to clear this up before settlement. So if the attorney does their title search and they find anything, they're going to work with the seller to get that cleared up. Seller also needs to provide to the closing attorney all information needed to obtain a written payoff statement from any lender regarding interest in the property as soon as possible after effective date. Seller designates the closing attorney as seller's agent with express authority to request and obtain on seller's behalf payoff statements or short pay statements from any such lenders. So one thing the attorney will have to get for any of the seller's outstanding liens is a payoff amount, and the lenders will calculate that payoff amount to the day of settlement. If settlement gets delayed, those amounts change. So to the day, I have only had one attorney that told us that it was my seller's responsibility to get that payoff amount. And I didn't know what to do. I didn't even know that was a thing. Every other attorney I've ever worked with has taken care of it for us, and it just magically happened. But I had the attorney call me like the week before settlement and said, when do you get your seller's loan payoff amount? I said, we got it. We figured it out as we went. But usually in my experience, and I'm sure you guys will have a similar experience, usually the attorney or the paralegal will communicate with the seller's lenders directly to get that loan payoff. If seller is not a foreign person, as defined by the Foreign Investment and Real Property Tax Act, seller shall also provide to the closing attorney a non-foreign status affidavit. In the event seller shall not provide a non-foreign status, seller acknowledges that there may be withholding as provided by the Internal Revenue Code. If there's any questions or concerns about what all that means, you guys pretty much know what I know about that provision. Call your attorney or call your seller's accountant. When I see Internal Revenue Code, I see accounting. So if there's any foreign investment, something like that that comes up, get the attorney involved, make sure the seller's handling that properly. Authorization to disclose. This is similar to what we saw in the buyer's paragraph, where anybody that needs a copy of the contract or anything to complete this transaction, the seller's given permission to disclose that information. So neither party can say, well, I didn't get your permission. Yes, I did. I did right here in the contract. Access to the property. Sellers shall provide, let's talk about this for a second, reasonable access to the property throughout the earlier of closing or possession by the buyer, including but not limited to allowing the buyer agent's representative an opportunity to conduct due diligence, to verify the satisfactory completion of negotiated repairs, and to conduct the final walkthrough. Seller, we can't go under contract and then the seller not let the buyer's people in to do their investigations and their inspections. The seller has to agree to let the home inspector in. They have to let the appraiser in. The seller can't deny. That would be denying the buyer of doing their inspections or investigations. As we said, the buyer has the right to verify satisfactory completion of negotiated repairs and to do the final walkthrough. Reasonable access. I would not consider 3 o'clock in the morning reasonable access. That's just me. That's what we mean by that. So the buyer just can't show up with their home inspector at, whatever time. They still need to, buyers need to understand this is not their property yet. They need permission to access the property. So they call you, I want to go to the house tomorrow and look at paint samples. Great, let me set it up. Every time you or your buyer's representatives want to go to the property, we need to schedule an appointment through showing time. We need to have the seller's permission to be there. Every once in a while, I had this happen once. My sellers were sitting in the living room one evening, it was like dusk, watching TV, and all of a sudden they see in the window, it was the buyers that we were under contract with. I was on the phone with the listing agent faster than or this buyer's agent. I was on the phone with the buyer's agent faster than what I could ever be on the phone with anybody. The buyer's agent was mortified. My buyers did what? Have the conversation with your buyers. Y'all, that's called trespassing if they're there without permission. Some sellers are not like my guys. Some sellers have like shotguns and stuff, so make sure your buyers understand it's not their home yet. I know we're excited, but it's not your home yet. And again, conduct the final walkthrough. I try to do the final walkthrough as close to settlement as I possibly can. Like we are on our way to the attorney's office. This note directs us back up to paragraph 4 for limitations on buyer's right to terminate during the due diligence. That's right. That's right. They got shotguns in Davidson County, don't they? Sure do. I'm down here in good old Randolph County. Oh yeah. Removal of seller's property. Seller shall remove by the date possession is made available to buyer all personal property, which is not part of the purchase, and all garbage and debris from the property. Again, another good thing to do the final walkthrough, because if there's a bunch of trash piled up in the living room and the buyer signs, that trash becomes theirs because they're agreeing to accept this property in its current condition. So another good reason to do the final walkthrough, make sure they're good with the junk that's left. I think sometimes sellers think they're leaving buyers gifts. I think what it comes down to is the seller decides they don't want to move it. So we'll just leave it here for the buyer. It'll be a nice housewarming present. Guys, if the buyer wanted it, they would have asked for it as personal property when they presented the offer. That comes up with the grill sometimes. The sellers get to it and they don't want to move the grill. So they say, oh, we'll leave this for the buyer. You know what the buyers say? Get that out of here. My grill's much nicer anyway. If I wanted that, I would have asked for it. Don't leave presents. Affidavit and indemnification agreement. Seller shall furnish at settlement an affidavit and indemnification agreement and form satisfactory to buyer and the buyer's title insurer, if any, executed by seller, and any person or entity is performed to furnish labor, services, materials, or rental equipment to the property within 120 days prior to settlement, and who may be entitled to claim a lien against the property as described in this general statute. I believe in pre-licensing, we refer to these people as mechanics. And what we want to avoid are mechanics filing a lien after settlement. Remember, mechanics lien is a specific lien, which means it attaches to the property. So the seller says, I agree to do repairs. Where do I sign? They do the repairs. They don't pay for them. We go to settlement. After settlement, the mechanic says, I'm not paid. I'm going to attach a lien to the property. The buyer, who now is the owner, has a lien on the property. So how do we avoid this? Well, when you submit your due diligence repair request, ask for paid in full invoices so you can see that they've been paid when the work is done. The buyer's title insurance company will have the seller sign something saying, I promise you this won't happen. That's their affidavit and indemnification agreement. I promise this will not happen. If they lie and they sign anyway, we find out after settlement that there's a mechanics lien on the property caused by the previous owner. Title insurance will go after the previous owner first. But if they're broke or dead or MIA, that's when title insurance is there to protect the owner. Title insurance protects the owner from errors of the past. But they are going to work hard to make sure this doesn't happen. One, in part by having the seller sign something saying that this will not happen. Designation of lien agent. If required by this general statute, seller shall have designated a lien agent, and seller shall deliver to buyer as soon as reasonably possible a copy of the lien agent. All deeds of trust, deferred ad valorem taxes, liens, and other charges against the property not assumed by the buyer must be paid and satisfied prior to settlement, so the cancellation can properly obtain following closing. So all of the seller's outstanding liens, anything that they owe, the attorney is going to pay those off, record that payoff before they record the buyer's new deed. The time stamp has to follow. You pay this mortgage off, and then you can record the deed and the new mortgage. Good title legal access. Seller shall execute and deliver a general warranty deed for the property in recordable form no later than settlement, which shall convey fee simple, marketable, and insurable title without exceptions for mechanics liens, free from any other liens, encumbrances, or defects, including those which would be revealed by a current and accurate survey of the property, except this year's ad valorem taxes that we're going to prorate through the date of settlement, utility easements on violated covenants, conditions, or restrictions that do not materially affect the value of the property, and any other such liens, encumbrances, or defects as may be assumed or specifically approved by the buyer in writing. This property must have legal access to a public right-of-way. What are we saying? Seller to provide general warranty deed, good marketable title. They've disclosed utility easements, anything we can find in the survey. We're going to prorate taxes. Again, that's the seller's biggest responsibility, is to provide the buyer with that good marketable title, that clear marketable title. And that's what their obligation, as it's spelled out here in the contract. This note, buyer's failure to conduct a survey or examine the title prior to the expiration of the due diligence does not relieve the seller of their obligation to deliver good title. So if we find out after due diligence that something's on the title, the buyer, that may be the out for the buyer if they can't clear it up, or if the seller won't clear it up. Does that make sense? So just because the attorney finds something after due diligence doesn't mean the seller's off the hook. The seller's biggest responsibility is to provide title, and they owe that to the buyer up until settlement. And then the second note is addressing if the property might be a short sale. We're instructed to include the short sale addendum. We'll look at this one in our forms as well briefly. Seller shall pay for what? Deed preparation fee and all other documents necessary to perform seller's obligations. And for what? Excise taxes and any deferred, discounted, or rollback taxes, local conveyances, etc. So the question of who pays for what, a lot of times it's spelled out responsibilities in the contract. Seller pays CDE, commission, deed prep, and excise tax. Then it says this deed is to be made to. Once again, we need the full names of all of the buyers that are taking title. Don't give me Mr. and Mrs. Campbell. Full names of all, everybody. Again, sometimes I've seen this where agents say how we're going to take title, like Tennessee by the entirety, joint Tennessee, Tennessee in common. Guys, remember, I'm not an attorney, so I can't advise buyers on how to take title. So when you're working with unmarried buyers, you want to make sure they have a discussion with their attorney for the attorney to explain if they should do joint tenants or tenants in common. Y'all don't feel that you can whip out your pre-licensing book and proceed to explain joint tenancy and tenancy in common. That's one of those topics we teach you just enough to be dangerous in pre-licensing. So you get a little bit of knowledge and you're like, I know how joint tenancy works. No, you don't. That's the attorney's job to explain. So if they have any questions on how to take title, direct them to their attorney. Agreement to pay buyer's expense. Seller shall pay at settlement X amount towards any of the buyer's expenses associated with the purchase price of the property at the discretion of the buyer or their lender, if any, including any FHA, VA lender and inspection costs that buyer is not permitted to pay. Right now, pretty much what we're seeing in this line is a big fat zero. Sellers aren't paying much of buyer's closing costs, but again, that pendulum will come back and this will once again be a negotiated amount. If the amount is zero, please don't leave this line blank. If it's zero, put zero in there. I know we talked about never leaving a blank blank. I'm reiterating, I'm reinforcing it with this one. If there's nothing, put NA or zero. If, for example, the buyer's a VA buyer and our FHA VA addendum says that the seller's on the hook to pay the pest inspection fee, then at a minimum, we need the amount of the pest inspection. That's what that last line is saying, including any FHA lender inspection costs that buyer's not permitted to pay. So even though they're not paying any closing costs, the seller has agreed by accepting the VA loan via the FHA VA addendum to pay the pest inspection, put the amount of the pest inspection in there. If the seller agrees to pay $1,000, if you put $1,000 in there and they have to pay the pest inspection, whatever their closing costs are going to be is the difference of the pest inspection. Does that make sense? They're going to take the pest inspection out of that $1,000. So buyer's agents, if you want $1,000 plus the pest inspection, then you put that in there. So everybody sees that makes sense to everybody. That pest inspection will come from that amount. No, just VA is the only one that will make sellers require sellers to pay anything. And again, we'll see that verbiage in our addendum. So just make sure you're filling out that line properly. We're told parties should review the addendum prior to entering into an amount in this line. Certain FHA, VA lender and inspection costs cannot be paid by the buyer at settlement, and the amount of those should be included in the blank above. Association fees and charges. Sellers shall pay any fees for confirming seller's account payment information, any fees imposed by an owners association in connection with transaction contemplated by this contract, other than the fees above. Fees incurred by sellers in completing the RPODs, any RSale related to proposed sale of property. Some HOAs will charge a transfer fee because you got to change paperwork. You got to delete this person's name and put that person's name in. So if there's a transfer fee, for example, the paralegal or the closing attorney will find it. So they'll know pretty much the seller usually gets to pay that unless the parties agree otherwise. That's what that paragraph is about. Here's special assessments again. Seller shall pay in full at settlement all special assessments that are approved prior to settlement, whether payable in a lump sum or future installments, provided the amount can be reasonably determined. The payment of such estimated amount shall be final payment between the parties. So the buyer pays for anything that's confirmed after settlement, The seller's responsible for paying everything that's been confirmed prior to settlement, whether or not due in a lump sum or future installments. So what they'll do is they'll contact the HOA. Let's say they were doing a special assessment. The HOA was doing a special assessment on the roofs. And they decided to break it down into 4 payments, installment payments. If we're going to closing and there's still 2 payments due, they're going to go ahead and collect that whole amount from the settlement. I'm sorry, from the seller at settlement. They're not going to keep trying to go after the seller saying your 3rd payment's due, your 4th payment's due. So that's what that's saying. Anything that's due, whether in a lump sum or future installments, will be handled at settlement by the seller. All property tax listing penalties, if any. So if the seller's delinquent on their taxes, they never paid 2021 taxes, the seller shall have to pay those at settlement. Negotiated repairs shall be made in a good and workmanlike manner, and buyer shall have the right to verify prior to settlement. So seller agrees to that. And then the last thing, the new 8N, see paragraph 23 for buyer's remedies in the event of breach of this contract. So if the seller breaches, we're spelling it out in this new paragraph 23. Questions on the the seller's obligations or responsibilities. Okay, isn't this fun? I know Forms Day, I know it, but guys, this is so important. Can we all agree with that at least? May not be your funnest way to spend a Saturday morning, but I mean, we're not watching Red Dawn or anything, but I mean, this is so important that we understand. Prorations and adjustments, unless otherwise agreed, the following items shall be prorated, with the seller responsible for prorated amounts of taxes and dues through the date of settlement, and seller entitled to the amount of prorated rents through the date of settlement, neither just between the parties. So again, our contract tells us that the seller's responsible for the date of settlement when we're prorating between the buyer and the seller. Things that we typically prorate, here's our this year's real property taxes. If the sale is including the car, we're going to prorate those personal property taxes. We're going to share that expense. Does the boat come with the house? Well, anything's negotiable. And if we negotiate the boat, then those personal property taxes will be prorated, rent, if any, and then owners association dues. Again, the owners association will provide if they're monthly dues, annual dues, quarterly dues, however those are assessed. Home warranty, select one of the following. No home warranty, which again, pretty much in this market, that's what we're seeing. That will change. Buyer may obtain a 1-year home warranty to cost not to exceed X amount, which does include sales tax, and seller agrees to pay for it at settlement, or seller has already obtained a warranty at a cost not to include. I just point this out. When you guys talk to your home warranty reps, your firms will probably have a preferred home warranty vendor. And when you get the brochures, the home warranty brochures, it gives the buyer costs of that plan, but it doesn't include sales tax. So just make sure when you're filling this amount in, you give a little bit more. And notice it says not to exceed. So if you put, $5,000 in here and the home warranty is only $500, that's all the seller has to pay, right? They only have to pay the amount not to exceed this amount, but just remember that you make sure to include sales tax. So if the brochure says $650, for example, go up just a little bit for sales tax. Risk of loss or condition of property at closing. The risk of loss or damages by fire or other casualty prior to closing shall be upon, please note this says seller. Seller is advised not to cancel existing insurance on the property until after confirming recordation of the deed. Listing agents, look at your seller and say, you've got to keep homeowners insurance on the property until that deed is recorded. Because the risk of loss is on the seller because it's still the seller's property. I've had sellers, we go under contract and they're like, sweet, I can cancel my homeowner's insurance policy. No, it's still your house. We're under contract. We are one step closer, but we're still not there yet. So make sure you have this conversation with sellers that they have to maintain homeowners insurance through the day of closing till that new deed is recorded.
So they're selling a home for $500,000, but they want to save $40 on a prorated portion of their
Thank
home
you.
loans.
Thank you. Aren't people funny?
Funny, to put it lightly.
Not haha funny, but kind of funny, right? You know? Thank you, Ariana. I agree completely. It's like 6 more weeks, 8 more weeks. I mean, really, you know, the house burns down, you don't have insurance. It's still your house, or it was. Now what do you have? Big old heap of ashes, right? Buyer's obligation to complete the transaction contemplated by this contract. Here's the only contingency in our offer to purchase and contract. Shall be contingent upon the property being in substantially the same or better condition at closing as it was on the date of this offer, reasonable wear and tear expected. If the property is not in the same or better condition as of the date of this offer, reasonable wear and tear expected, buyer may terminate this contract by delivering written notice to the seller, and the earnest money deposit shall be refunded to the buyer. Does that say due diligence? It says if the buyer terminates because the property's not in the same or better condition and they choose to terminate, they will get their earnest money back. If the property is not in condition and the buyer does not elect to terminate, buyer shall be entitled to receive, in addition to the property, the proceeds of any insurance claim filed by the seller. We're under contract, the house burns down. It's not over yet. The buyer has a choice. They terminate and get their earnest money back, or they proceed, purchase the property, and they're entitled to the insurance claim filed by the seller. If I were a buyer's agent and this happened, and my buyer looked at me and said, oh my God, what should I do? I would advise them to talk to an attorney, and I would advise them to talk to the seller's insurance company before they made a decision. Thoughts on that? I don't know how many times I teach this class and I read that, I always go, wow, that's an option. All right. Comments on that? Okay. Here's this delay in settlement that we've been talking about, saying we're going to get to this provision. Shall apply if one party is ready, willing, and able to complete settlement. They're going to be called the non-delaying party. But it's not possible for the other party to complete settlement by the settlement date. They're known as the delaying party. Delaying party shall be entitled to a delay in the settlement and shall give as much notice as possible to the non-delaying party and the attorney. If the delaying party fails to complete within 7 days, then the delaying party shall be in breach and the non-delaying party may terminate. I need everybody to note of this 7 days. This was a change as of July 2021. Prior to last year, it was 14 days. So when you come across old literature in your book, and I was looking to see where that specifically might be, and I haven't found it yet, but it's in here somewhere, I'm sure. So when you come across any old literature that says 14 days, I need you to cross it out and write 7. And of course, I can't find it right now because I'm looking for it, and that's how that goes, right? Another good reason to make sure you're always looking at the current forms. So prior to July of 2021, it was 14. So this is what this is saying. Let's pretend that the buyer's the delaying party because we don't have loan approval yet. Nothing's wrong, everything's okay. We just don't have the official go-ahead yet. So we have to delay settlement. The buyer would be the delaying party, the seller is the non-delaying party. If we're delaying settlement because the buyer can't get loan approval, the seller has no choice but to sit still and be patient for 7 days. They just sit there. And everybody's got their fingers crossed that this thing works out. On day 8, if we still haven't closed, the seller has the right to terminate. Buyer would be in breach and would suffer the consequences of breach. What if the seller terminates on day 5, delay day 5? Now the seller's in breach. That's what that 7-day delay means. The non-delaying party has no choice but to sit still and be patient for those 7 days and hope that whatever's causing this delay gets worked out. Remember, we looked at our agreement to amend the contract last weekend, and we saw where we could agree to negotiate a new settlement date. We still can. We're changing the date, the contract. But if we're not negotiating a new date, there's a 7-day delay. Questions on that? Possession of the property, including all means of access to the property, such as keys, codes, security codes, garage door openers, electronic devices, shall be delivered upon closing as defined in paragraph 1M above. Closing is what? What's the very last step of closing? The brand new deed is recorded. Buyers should not be getting keys or access until the new deed is recorded. The parties may agree to do a buyer possession before closing or a seller possession after closing. We'll look at both of these forms as well, talk briefly about those. Or if you have a tenant purchasing the property, they already live there, right? So they already have possession of the property. So possession has already happened. And again, we're reminded to attach the additional provisions addendum or the vacation rental addendum if applicable to this situation. So as we said, and I've tried to point out, scattered throughout the contract, when we have the need to use an addenda, it tells us. If you look at the form, if you're paying attention, do I need an addenda? The contract does a really nice job of helping us out. In addition to being scattered throughout the contract, provision 14 gives us this nice little handy dandy checklist. This is another opportunity for us to go through and make sure everything that's applicable to this transaction is included. So use this, you got to check the boxes. Yes, FHA, yes, backup, whatever. I got a text last week from a lady I had in pre-licensing, and then she came to me in this class in post-licensing as well. And she put her first buyer under contract last week. So she was all like, ee, all excited and everything. And she said, Julie, my very first contract, I had the lead-based paint hazard addendum. I had the FHA VA financing addendum, and she had the additional provisions addendum. She said, could I have used any more? And I'm like, oh, I'm sure you could have. But what I need you guys to understand is that every transaction is different. So the addenda you use for this transaction might be the different than next one. And that's why I need you guys to really make sure you're reviewing this before you submit it. And if you have included all applicable addenda, because the only way those addenda count is if you add them. If you don't add them, they don't exist. Questions on that? You have to add them for them to be applicable. We are reminded in this note, we are not permitted to draft addenda to this contract. I cannot draft legally binding documents, period, end of story. Assignments, remember we said an assignment, you're transferring, all the terms stay the same. The only thing that changes is the names of one of the party. This contract may not be assigned without the written consent of all parties, except in connection with a tax deferred exchange, which we'll talk about next. If it is assigned, then this contract shall be a binding on the assignee and the assignee's heirs. The assignee would be the receivee of the assignment. So the new name on this contract is who would be obligated to fulfill the forms of this contract. Tax deferred exchange. This is a great tool for an investor. If you are an investor, you want to work with an investor, have your investor speak to an accountant. Tax deferred exchange, the investor can sell an investment property and use the proceeds of that sale to purchase another investment property. And if they're using the money from this sale to purchase another investment property, they can defer paying capital gains taxes. So if you're an investor or you're working with an investor, once again, I just told you guys just enough to be dangerous. So if you're an investor working with an investor, have them call their accountant. That's why you know this information, because we have a flag that goes up that should encourage them to call their accountant. So in the event the buyer or seller desires to effect a tax deferred exchange in connection with the conveyance of this property, buyer and seller agree to cooperate in effecting such exchange, provided, however, that the exchanging party shall be responsible for all additional costs associated with the exchange. The non-exchanging party will not assume any additional liability. Buyer and seller shall execute such additional documents, including an assignment, at no cost, at no exchanging party, at the non-exchanging party, and shall be required to give effect to this provision. So you got the attorney involved drafting up the applicable paperwork. You got the accountant involved getting advice. You and I are just helping to push the people in the right direction. Questions on that, comments? I've heard this is because this is an IRS program, something they allow investors to do. I heard this might be up for review soon. So I'll be interested to see what the outcome of that's going to be. Rest assured, they'll update our forms, they'll update us, but I'll be interested to see where that's going to lead. Time will tell, I guess. Parties. This contract shall be binding upon and shall inure to the benefit of buyer and seller and their respective heirs. When do heirs kick in? Yeah, such dramatic. After an individual passes away. So remember what we said, death is only an out when you're negotiating an offer. Once you're under contract, death is not an out. What's the contract say? And their respective heirs. So if buyer or seller pass away, their heirs are expected to carry out the terms of this contract. And if they can't or won't, then they will suffer the consequences of breach as spelled out below. Boilerplate stuff. Rest of this is pretty much boilerplate stuff, so this will be fast. Words in the singular include the plural and the masculine and the feminine, neutral genders as appropriate. Survival, any provision contained which by its nature and effect is required to be observed, kept, or performed. It shall survive closing and remain binding upon for the benefit of the parties. This contract is the entire agreement. In other words, the judge is not going to piecemeal it. and say this provision's okay, but this one's not. It's the contract. It's all or nothing. Entire agreement. All changes, additions, or deletions must be in writing and signed by all parties. Nothing contained shall alter an agreement between a realtor and their broker, or I'm sorry, the realtor or the buyer or seller, as contained in our agency agreements. So remember, our agency agreements is where we spell out our compensation. Our compensation doesn't belong here. We spell it out in our agency agreements. Parties shall agree that any action between them relating to the transaction contemplated by this contract may be conducted by electronic means. Remember last week we talked about the UETA and the e-sign. So in addition to them requiring you to agree to the terms before you adopt and sign through, for example, dot-loop, the contract also spells out that we may do this via electronic means, including the signing of this contract by one or more of them and any notices or communication given in connection. Any written notice or communication may be transmitted by mailing address, email, fax, set forth below in the notice information that we'll see after lunch. Any notice or communication to be given to a party and any fee, deposit, or other person may be given to the party or to such party's agents. Delivery of any notice to a party via means of electronic transmission shall be deemed complete at the time that the sender performs the final act, and to send such transactions in form capable of being processed by the receiving parties to any electronic information, provided in the notice information. Seller and buyer agree that the notice information and acknowledgement receipts sections of this contract are not a material part of this contract, and that the addition or modification does not constitute rejection of an offer or the creation of the counteroffer. Basically, what that last sentence is saying, the last 2 pages of your contract are not technically part of the contract. Failure to complete the notice information and failure to complete the acknowledgement of the receipts of money does not affect the validity of this contract. So the good news is our contract technically is only 13 pages. They just provide us with the last 2 to help the things move along. So again, we'll look at those after lunch. I am watching my time, don't worry. We'll go to lunch in just a second. Execution may be signed in multiple originals or counterparts, all of which together. I think in today's age of e-signatures, we're getting all signatures on the same document. So that's, you know, before you could have seller sign one and buyer sign one, and that was acceptable as long as they were signing just copies of the same thing. And the last thing I want to say before we go to lunch, computation of time. Unless otherwise provided for the purposes of this contract, we're not counting about closing disclosure time anymore. For the purposes of this contract, days shall mean consecutive calendar days that does include Saturday, Sunday, and holidays. For the purpose of calculating days, the count of days begins on the following day upon which any act or notice is provided. So again, we saw that with the CD, didn't we? So if you receive something today, tomorrow is day 1. But the difference in CD law and contract law, a day is a day is a day is a day. So if you put in 15 days, day 1 is tomorrow, that counts Sunday, that counts holidays, that counts Saturday. A day is a day in contract law. Questions, comments? We're at a great stopping point. So let's go to lunch. When we come back, I want to finish the contract. I feel like we're on a good roll, so I want to finish it. So we're going to look at our new paragraph 23, remedies for breach. We'll finish it up, wrap it up, and then we're going to take a break from forms, and we're going to do closing disclosure number 2. So if you haven't done that yet, you may want to look at it this next hour, and we'll talk about it, and then we'll start looking at our forms and that kind of thing. So I got 12:29. Let's take an hour lunch. We'll log back on, get started at 1:30. I'll come on like 5 minutes early or something so you guys can join me. You guys have a great lunch, and I'll see everybody back here at 1:30.